see that we've got cameras in court, and I take it that you've all read the directives regarding how you should behave in court. We don't expect you moving around because that may cause some disturbances. We may proceed.
In the matter of democratic alliance, this is the 18 NPA plus 2 others. That will be Jacob Zuma, the President, and Society of Protection of our Constitution. Case number 19577 of 2009.
May it please the Court Justices, Mr. De Waal, Mr. Borgstrom, and Mr. Vakele and I appear for the applicants in this matter.
May it please the Court, I appear for the first and second respondents together with Mr. Manechi and Mrs. Platt.
My Lords and Lady, I appear for the third respondent together with my learned friends Gabriel, Ghani and Kumar.
As concluded, my Lord, I appear for the Society for the Protection of our Constitution with the amicus. Thank you. Thank you.
Mr. Rosenberg, you may proceed.
Thank you, Justice Vitaba. We've prepared a chronology which we'd ask leave to hand in merely to facilitate the oral argument that we are going to be submitting. It contains a number of references which we think are important, but the purpose of it is to assist the flow of the argument and to prevent unnecessary referral to the record. Included in that chronology as well, on the last page, is a page reference to each of the volumes in question. So if there's a reference to a page, the Court will, without undue inconvenience, be able to locate the volume in question. How many copies have you got there? There's 3. And furthermore, we've prepared a copy of the main authorities that we are going to be referring to. We have a copy for the Court, 3 copies for the Court, which I beg leave to hand up as well. Justices, as far as the outline of the argument is concerned, it's going to be abbreviated and reformulated in one respect. Counsel for the National Prosecuting Authority has indicated to us that the National Prosecuting Authority is, in view of the provisions of Section 22(9) of the National Prosecuting Authority Act, not going to advance the proposition that the National Director of Public Prosecutions lacks the authority to institute a prosecution. And secondly, we've been advised by counsel for the National Prosecuting Authority that the authority's approach for the purposes of this case is going to be that the decision to prosecute, the 2007 decision to prosecute Mr. Zuma, was correctly to be categorized as a corporate decision. And in view of those indications, it has obvious implications for the arguments that we've put up on the heads of argument to the Court, and in particular, the alternative argument that we put up as to non-compliance with Section 179(5)(d) of the Constitution. And depending upon the shape of the argument as it unfolds, it may be that we advance no submissions in that regard. Some preliminary background remarks for contextualization are necessary. The Court will be well aware of the history of this matter, but nonetheless some brief remarks as to certain milestones in the matter which are important, and particularly so in view of the nature of the rationality challenge which is being advanced in this matter and which will be developed in due course. That rationality challenge is centrally predicated upon the contention that Mr. Moshe, the decision maker, part of the decision maker, well, in fact, the decision maker as far as the discontinuation is concerned, failed to take proper account of or failed to attach sufficient weight to the nature and circumstances of the corruption and related charges. Now, on the 19th of June 1999, Mr. Zuma became Deputy President. On the 23rd of August 2003, the then National Director, Mr. Nguku, held a press conference to announce that while a prima facie case existed against Mr. Zuma, he wouldn't be charged. However, Mr. Shabia Sheikh was to be charged, and we know that the latter's trial commenced in 2004, and that on the 2nd of June 2006, he was found guilty on charges of fraud and corruption with a sentence of 15 years. And it would appear to be common cause that that conviction had significant consequences for a potential prosecution of Mr. Zuma.
Mr. Rosenberg, we refer to that third respondent should be referred to as President Zuma.
As the court pleases. The reference then was just in the sense that the third respondent at that stage wasn't the president, but of course I'll follow that. In the Sheikh prosecution, the state had alleged that over a period of some 5 years, from 1994 to 1999, substantial amounts of money had been paid by Mr. Sheikh and his companies to and behalf of President Zuma, and that this was done corruptly and with the object of influencing the president to use his name and political influence. On the 14th of June 2006, following those findings, the then president of the country, President Mbeki, dismissed President Zuma based upon the findings of the KwaZulu-Natal court that the relationship between President Zuma and Mr. Sheikh was unsavory. And this was followed up a week, well, in fact, on the 20th of June 2005, the decision of the then National Director of the National Prosecuting Authority, Mr. Picoli, to charge President Zuma was announced, and amongst the reasons for this fresh decision was the emergence of significant and weighty evidence which had emerged during the Sheikh trial and the facts which had been there established. And after President Zuma's appearance in the Durban Magistrates Court on the 29th of June 2005, the investigation continued and was broadened with a series of search warrants being obtained. The court will be aware that the obtaining of those search warrants led to a plethora of proceedings challenging the validity of the processes. That slowed down the progress of the investigators. In addition, the state had also applied to the KwaZulu-Natal High Court for a letter of request to the Attorney General of Mauritius. These proceedings led to the slowing down of the criminal charges and the prosecution thereof, and the court will have seen that on the 20th of September 2006, Msimang J refused the state's application for a postponement of the trial of Mr. Zuma, and the matter was struck off the roll. However, On the 8th of November 2007, the SCA handed down judgments in the appeals involving the search and seizure cases, in which the NPA was substantially successful. And we would submit that in the wake of that finding, the prosecution of President Zuma had, or against that background, the prosecution of President Zuma, which had become effectively inevitable after the Sheikh findings of mid-2005, had now been significantly strengthened by the additional information and documentation that had been obtained in the wake of the further proceedings. Now, against that backdrop, we need to turn to the reasons for the subsequent decision to discontinue the criminal proceedings. Before I do so, I'd like to make a few submissions in relation to the question of rationality as a basis of a legality review, that being the principal attack or basis for the attack on the decisions in question. The court will have seen from the submissions the applicant's reliance on the pharmaceutical decision. We have quoted the dictum from Chaskelson P. in that matter, where he said it is a requirement of the rule of law that the exercise of public power by the executive and other functionaries should not be arbitrary. Decisions must be rationally related to the purpose for which the power was given. Otherwise, they are in effect arbitrary and inconsistent with this requirement. And that traditional test or requirement for rationality, namely that the decision in question must be rationally related to the purpose for which the power was conferred, has been confirmed in any number of cases since then. In particular, we've referred to the decision of the Constitutional Court in the DA versus the President of 2013, 1248. That decision can conveniently be referred to as the Similani decision to identify it. The Constitutional Court has emphasized that there may be an overlap in the concepts of rationality and reasonableness. But at least on a conceptual level, one should continue to distinguish them. Of course, reasonableness as a concept in administrative law arises particularly in relation to Section 62H of PAJA, which postulates a relatively simple reasonableness test. Namely, the administrative action has got to be one, or it will be reviewable if it's one that a reasonable decision maker could not have reached. Formulation that we've encountered in Beto Star, decision referred to in our heads of argument. As indicated, rationality review is principally concerned with the relationship between means and ends. The relationship, the connection, the link, as it's variously referred to, between the means employed to achieve a particular purpose on the one hand and the purpose itself. And of course, the aim of the evaluation is not to consider the possibility of better means to achieve the purpose. It's to consider a rational relationship between the means and the purpose for which the power is concerned. And we're going to be returning to and emphasizing that the rationality requirement has got to be properly adhered to. There is content to the rationality requirement. It's frequently asserted by decision makers faced with a rationality review that the level of scrutiny in the context of the rationality test is so limited as to really, in fact, amount to little more than a formality. We assert to the contrary that in the light of the authorities that we referred to and this emphasis on a rational relationship, the means and ends, and the connection that must be established, that test as formulated must be carefully and properly applied to the exercise of any public power. The Court will be aware that the Constitutional Court has held on at least 3 occasions, we've referred to the authorities in our heads, that the principle of legality requires, of course, that in addition, the process by which the decision is reached must be rational. And related to that notion of procedural irrationality, the failure to consider relevant facts may render a decision irrational. That much was emphasized by the Constitutional Court in Similani, where it emphasized that if in the circumstances of the case there's a failure to take into account relevant material, that failure would constitute part of the means to achieve the purpose for which the power was concerned. And if that failure has an impact on the rationality of the entire process, then the final decision may be rendered irrational. And the final remark we would make in the context of irrationality is that, of course, the power mustn't be misconstrued. SAFU, paragraphs 27 Similani, paragraph 27, and SAFU in paragraph 148 make that point. And against that background, perhaps then the appropriate starting point is the purpose of the power. The power that was exercised in this matter was a power conferred by Section 179 of the Constitution and conferred by the relevant provisions of the National Prosecuting Act, amongst others, to discontinue a prosecution. Section 21 of the National Prosecuting Act confers the power on the prosecuting authority to both institute and conduct criminal proceedings and to discontinue criminal proceedings. And of course, linked to that power is the power that we've referred to in terms of Section 179(5) of the Constitution, repeated in Section 22(2)(c) of the NPA, to review either a decision to prosecute or a decision not to prosecute. The NPA's prosecution policy has been referred to in the papers. The policy emphasizes, not surprisingly, the fundamental point that crime can't be allowed to undermine the constitutional democracy in South Africa, and hence the efforts of the prosecuting authority are directly addressed to reducing pervasive criminal activities. And that's taken from the prosecuting policy of the NPA. And it emphasizes that effective and swift prosecution is essential to the maintenance of law and order within a human rights culture. Offenders must know that they will be arrested, charged and detained where necessary, prosecuted, convicted and sentenced. So much for fundamental propositions with which nobody would have any argument as articulated in that prosecution policy. A final remark in that context is that effective and impartial prosecution of crimes is fundamental to a myriad of constitutional rights. In this matter, the court will be aware that the charges were charges that bore on allegations of corruption. The court will be aware that in the decision of Glenister, the 2011 decision of Glenister referred to in our heads, the citation is 2011-347, the then Chief Justice emphasized that corruption was a scourge that had to be rooted out of society. I'm not going to read the extracts from Glenister, and particularly dicta from Moseneke, Deputy Chief Justice, and Cameron, other than to just emphasize and recite one short paragraph, because it's in particular, and we'll be coming back to this, it's of particular importance in determining the role and significance of these particular charges and whether, in fact, the offence or conduct of Mr. McCarthy, as revealed in the tapes, was of such a character and more particularly linked or properly linked to these charges to warrant the prosecution on the charges in question being discontinued. And in that context, in Glenister too, Moseneke, Deputy Chief Justice, and Cameron J. said at paragraph 166 that there can be no gainsaying that corruption threatens to fell at the knees virtually everything we hold dear and precious in our hard-won constitutional order. It blatantly undermines the democratic ethos, the institutions of democracy, the rule of law, and the foundational values of our nascent constitutional project. And in paragraph 167, the court went further and emphasized as follows: this deleterious impact of corruption on societies and the pressing need to combat it concretely and effectively is widely recognized in public discourse. And closer to home, as it were, in the Sheikh appeal in the Supreme Court of Appeal, the appeal decision S.V. Sheikh, the court similarly pointed out that the seriousness of the offence of corruption cannot be overemphasized. It offends against the rule of law and the principles of good governance. It lowers the moral tone of a nation and it negatively affects development and promotion of human rights. So against that background, one turns to the reasons for the decision. And the reasons for the decision appear as Annexure JS10 at page 120 of what is referred to as Volume 1B. The court, and we apologize for that, there was a little bit of an unhappy preparation of aspects of the bundle. And in our practice note, we've indicated which volumes of the record have to be or ought to be considered by the court, and those ran from volumes 1 to 32, but the original founding affidavit and annexures was not included, and they were subsequently prepared in 2 volumes, one capital A and one capital B. And so for convenience, when I refer to volumes, I'll refer to volume A, volume B, and that's 1A, 1B, and I'll then refer to the volumes sequentially from one after that. So against that backdrop, one then turns to the statement by Mr. Masher of 6 April 2009, which appears at 120. The point that we submit must be borne in mind is that the NPA in its submissions accepts that the rationality of the decision must be assessed on the basis of the reasons furnished by Mr. Mshe at his press conference at 6 April 2009. And the NPA in its submissions, and this also formulates or guides the submissions that we make, the NPA has said that inasmuch as the answering affidavit of Mr. Hofmeyr traversed a range of additional matters and material going to show possible political interference and conspiracies in other instances, this was done, I quote, only to provide context and background to the decision. And on that basis, which appeared to be common cause between the applicant and the NPA, that the reasons for the decision are to be located in JS 10. And I'm not going to take the court through the authorities we referred to in our written submissions, going to when it is permissible to introduce additional reasons not relied upon in the original furnishing of the reasons to justify a decision, and when it's impermissible. The decision of Mr. Mashe pivoted on what he referred to as the abuse of process doctrine. And in his submissions, or in his reasons, Mr. Mashe at page 121 of Volume B refers to the fact the NPA had received representations, both oral and written, and that they dealt with the substantive merits, the fair trial defences, that's the second bullet point in the middle of the page, the practical implications and considerations of continued prosecution, and the policy aspects militating against prosecution. With regard to the first three issues, Mr. Mashe stated that he couldn't find anything with regard to those grounds that militated against a continuation of the prosecution, and hence they're not dealt with in any detail. He focused, as he stated, on the fourth ground, which he considered to be the most pertinent for the purposes of his decision. And at page 123, in this connection, Mr. Mashe introduced the concept of abuse of process. And he points out at page 123 that there are generally two categories of abuse of process. It may occur either A, because it will not be possible to give the accused a fair trial, or B, where it will offend one's sense of justice, integrity, and propriety to continue with the trial. And that much appears from the bottom half of page 123. Having referred to the so-called two general categories, which for the most part bear on the question of fair trial, he goes on to say that it's not only where fair trial is implicated, directly implicated, that the abuse of process doctrine or approach falls to be or may be applied. As he says at the foot of the page, fair trial, third line from the bottom, 1, 2, 3, fair trial is not the only test of abuse of process. Abuse of process may occur on its own, either because it will not be possible to give the accused a fair trial, or B, it will offend one's sense of justice, integrity, and propriety to continue with the trial of the accused in the particular case. Discontinuation is not a disciplinary process undertaken to express one's disapproval of abuse of process. It's an expression of one's sense of justice and propriety. And he goes on to quote from a number of decided cases in overseas jurisdictions. He quotes in particular the House of Lords decision in R versus Latif, as well as extracts from the British decisions of R v Martin and a decision reported in 1991, 3 All England reports of R versus Hui Chi Ming. And at 130, if I could ask the court to turn to that page, he concludes, and he says at the top of the page, it's against this broad principle of abuse of process that the conduct of Mr. McCarthy must be seen and tested. The question for close consideration is encapsulated in expressions such as so gravely wrong, gross neglect of the elementary principles of fairness, so unfair and wrong, and misusing or manipulating the process of court. If the conduct can be so categorized, it would be unconscionable for the trial to continue. And he goes on to say in the 4th paragraph, in the present matter, the conduct consists in the timing of the charging of the accused. In general, there would be nothing wrong in timing the charging of an accused person, provided there's legitimate prosecutorial purpose for it, and the accused is aware, should be aware, or has been made aware of such purpose. It follows, therefore, that any timing of the charge of an accused person which is not aimed at serving a legitimate purpose is improper. And it's against, or in that context, that one concludes that fundamental to the decision of Mr. Moshe was his conclusion that the conduct of Mr. McCarthy offended his sense of what was right. It offended his sense of elementary principles of fairness. It was so unfair and wrong, to quote or to refer to the specific phrases that he used. It was so unfair and wrong that it should be discontinued. The prosecution should be discontinued. The first submission we'd make in this context is that the abuse of process doctrine is not one that's been directly addressed in our case law. But having said that, and if regard is made to the decisions referred to by Mr. Mshwe, the first point to be made is that those decisions involved circumstances under which a court, and for present purpose we don't suggest that a lot turns on it, but nonetheless they were decisions in which a court might order a prosecution to be stopped. And in the Hong Kong Appeal Court decision that we've referred to in our heads of argument at footnote 92, the Hong Kong Appeal Court decision of Lee Ming T, which referred to R.V. Latif and pointed out that it was generally accepted that it was only in exceptional circumstances that a stay will be granted where a fair trial is possible. And reference was made to a dictum in the Canadian court that a stay of proceedings is only appropriate in the clearest of cases, where the prejudice to the accused's right to make full answer and defense cannot be remedied, or where irreparable prejudice would be caused, and this is in a situation where fair trial is not implicated, where irreparable prejudice would be caused to the integrity of the judicial system if the prosecution were continued. And in paragraph 184 of Li Ming Ting, the court emphasized that the existence or otherwise of an abusive process was dependent upon the exercise of a judicial discretion, and as pointed out by Lord Steyn in Latif, this judicial discretion involves a weighing of countervailing considerations. It involves a weighing up, on the one hand, of considerations of policy and justice on the other.
Is that, I'm sorry to interrupt, is that in the case where it goes to a court?
Yes.
The court will then
Yes.
weigh that, yes.
And of course, to the extent it bears emphasizing, Mr. Mashere was approaching this basis on, or approaching this decision by employing the abuse of process doctrine to guide him, and relying particularly on Latif for the proper approach. And we've made the point that for present purposes, we're not going to be emphasizing that this is a decision for a court. Not going to be saying, in this context, this is a decision which Mr. Mashere should never have made, he should left over for a court. We make that submission in a slightly different context. But nonetheless, for present purposes, if, whether by a decision maker in the position of Mr. Mashere or in the context of that court, a consideration of whether there has been an abuse of process which warrants the discontinuation of a prosecution involves, and we would submit the reasons furnished by Mr. Mashere recognize this, involves essentially a two-stage test. It involves a determination of whether there has been an abuse, and moving on to the second inquiry, it involves a weighing up whether the nature of the abuse is of such a character, and we would say sufficiently linked to the prosecution in question to justify a stay of that prosecution, and to justify, as it were, the policy considerations in favor of continued prosecution being overridden by considerations of what Lord Steyn referred to as considerations that he encapsulated as being relevant to the question of justice or fairness. For example, in Latif, Mr. Latif had been the victim of an elaborate entrapment process, without which he would never have entered Britain. And it was in the context of that elaborate entrapment process that Mr. Latif entered the country and carried out the crime for which he was charged. And in that matter, Lord Steyn concluded that notwithstanding the court's, or notwithstanding the possible injustice as a result of the entrapment process, the public interest in ensuring the prosecution process continued outweighed that injustice. So, similarly, in another one of the decisions referred to in Mr. Mashere's reasons, R versus Martin, I'm not going to take the court there, it's in our written bundle. Lord Clyde said, and this was quoted by Mr. Mashere, Lord Clyde said, in relation to abuse of process, there must be something so gravely wrong to make it unconscionable that the trial should go forward, such as some fundamental disregard for basic human rights, or some neglect of elementary principles of fairness. Again, we emphasize there is that link between the abuse and the question of fairness, breach of human rights. It doesn't, of course, go to the question of a fair trial itself, but in the context of the entrapment cases, it went to the means which were utilized, used and abused to bring that particular accused before the court. And similarly, a decision such as Bennett, the British decision of Bennett, which perhaps represents the the high water mark of the abuse of process doctrine, one is dealing there with a case where the accused was as a result of a misuse or manipulation of extradition procedures that the court found to be totally irregular. The accused in that case landed up before a British court, and that was a decision, unlike decisions such as Latif and Martin, that was a decision where the court found that that particular abuse, which had led to the accused unfairly and improperly being brought into the country, could not be tolerated. And that's a point that we submit as of fundamental importance in considering the nature of the abuse, and particularly the question of a connection between the abuse and the prosecution in question and the concomitant decision to discontinue the prosecution. Insofar as the question of abuse of process as a basis for discontinuing a prosecution may in some form have presented itself in our courts, we've referred to the dictum of Harams J.A. in NDPP versus Zuma 2000.
Bennett's decision. What was the decision of the court?
In
the case of Bennett that you've just referred to.
Yes, in the case of Bennett, and that is referred to in the bundle of authority. I don't think that we managed to get those up to the court, unfortunately. Can we hand those up to you, Justices? That's decision 10.
Going into the details, I just want to know, how did the court decide?
Yes, the court there concluded that the misuse of the extradition processes in question, and the background is usefully just set out in the head note, you needn't go there, it's 137, but that was the case where that abuse of process in those facts was considered to be sufficiently linked to the prosecution and to be of sufficient magnitude to outweigh policy considerations that prosecution should continue.
But that prosecution was linked, the abusive process was part of the case.
Yes. That's the link.
Yes.
That's the point that I'm trying to make.
Yes.
Bennett, there was no suggestion that Bennett wouldn't receive a fair trial.
Yes.
They're over there, but the means by which he had landed before the court.
They got the facts to get him before.
Yes. And that may be contrasted with Latif, of course, where also the means utilised, the entrapment, to bring him into Britain, commit the crime, and hence to be arrested as part of an elaborate sting, were in that context held not to be sufficient to outweigh the public interest in prosecuting the crime. I was referring to the dictum of Harams J.A. in the Zuma case.
Sorry, my Lord, it's President Zuma. Thank you, my Lord.
In the President Zuma case. The case is to be found And at item 4 of our bundle of authorities, I'm not going to take you there. You'll be well acquainted with the dictum in question. I'm just going to read briefly from one paragraph, paragraph 93 of the decision of Harams DP, and the court will be aware that this was the appeal against the decision of Nicholson J. in Natal in the matter that's been referred to as the 179.5 matter, where there was a challenge by President Zuma to the lawfulness of the decision to reinstitute or to prosecute. And in the context of that challenge, which was essentially framed upon the basis that the decision to prosecute that was subject to the challenge effectively amounted to a review or reconsideration of Mr. Nguka's earlier decision not to prosecute, and hence Section 179.5 of the Constitution found application, and it being the contention on behalf of President Zuma that there had been a failure to comply with the requirements of Section 179.5d, in particular to take representations from President Zuma. And the court will be aware that in the judgment of Nicholson J. upholding that attack, there was reference to a political conspiracy, political interference, political motives perhaps for the prosecution. And in paragraph 37, in discussing the extent to which Nicholson J. had given credence to and to some extent taken into account in reaching his conclusion to set aside the decision to prosecute, to the extent that he had taken into account political or improper motives at play, Harams DP said the following. He said at paragraph 37, the Nicholson Court, dealt at length with the non-contentious principle that the NPA must not be led by political considerations, and that ministerial responsibility of the NPA does not imply a right to interfere with a decision to prosecute. The court then said, well, that needs some contextualization. A prosecution is not wrongful merely because it's brought for an improper purpose. It will only be wrongful if, in addition, reasonable and probable grounds for prosecuting it are absent, something which was not alleged by President Zuma and which he went on to indicate can only be determined in certain circumstances. He did go on to say, Harams DP, that that doesn't mean that in all circumstances the question of ulterior purpose is irrelevant, and he cited an example where the use of powers conferred on a prosecuting authority may be unlawful if used for an ulterior purpose. And he referred to the decision of Highstead Entertainment, where in that matter the police had confiscated certain machines belonging to Highstead for the purpose of charging it with gambling offences. The police were intent on confiscating further machines. Harams DP pointed out that the object was not to use them for exhibits. They already had more than sufficient exhibits, but to put Highstead out of business. And he said in that context, the intended or the confiscation had nothing to do with the prosecution at all. And the power of confiscation in that case was misused or used for a purpose not authorized by the statute. So that was the power of, specifically, it was that confiscation that was set aside. We would submit that it is important to recognize the context in which Harm's DP made his remarks. And that context, as I indicated, was one where the political interference was raised in one form or another on behalf of the third respondent, President Zuma, and which did find favor with the court below when upholding the application. And in that context, we say that what is required is that where a prosecution may or might have been influenced or driven by some improper purpose in the form of political interference, there's an additional requirement. Reasonable and proper grounds or probable grounds for prosecution have to be absent. And in our submission, in the context of an abuse of process approach adopted by Mr. Mashe and the facts of this case, the NDP case to which I've referred represents Supreme Court of Appeal authority that a court will not interfere with a decision to prosecute, even if improper purpose, ulterior purpose in the form of some political interference can be shown, unless reasonable and probable grounds for prosecution can be shown to be absent. That, in our submission, is what the NDP case is authority for. And we make that proposition or submission, particularly in the context in which Harm's DP made his remarks. And against that consideration of those authorities, if one can return then to the rationality requirement and the evaluation of the relationship between means and ends, one's dealing, as I've indicated, with the exercise of a power to discontinue a prosecution. The end, presumably, is to address properly the abuse of process which had occurred. And we would start off by making the proposition that that abuse of process in no ways or in no material way affected the third respondent. And to the extent that it did affect the third respondent, particularly insofar as the question of delaying the service of the indictment until...
Sorry to interrupt you before you go to that aspect. The way I understand the papers is that the decision to discontinue was made on the 1st of April already.
Yes.
And so your argument, you are saying that we need to evaluate if that decision was made, proper consideration was taken in respect of the rationality of the decision.
Yes.
Okay, I follow.
Yes.
Continue.
The point I'm making is that one was to deal then with the exercise of the power to discontinue the prosecution. That was exercised, as you point out, Mr. Justice Ledwaba, on the 1st of April, with the end, the presumable end or intention of the exercise of the power to properly address the abusive process. The decision to discontinue the prosecution was taken because of the abusive process. And the question is, well, if one was exercising the power to discontinue the prosecution for the purpose in some way of addressing and dealing with the abusive process, it was because of the abusive process that the discontinuation decision is taken. And it's there that one's looking for a rational link between the two. And the preliminary point that I made before, I'm going to turn now to say, well, let's analyze the abusive process to see whether there is this link. The preliminary point.
I would like you to assist us in respect of the contents of the letter in D7.
The letter
It's a letter addressed. It's D7. It's a letter addressed to Haley and Associates, and there's a signature there dated 30/3, and the date is March 2009.
30th of March 2009.
No, it just says March 2009.
Yes.
I think it's D7.
Yes.
When reading through the papers, this letter was a draft. It's a draft letter that was to be sent to Haley and Associates.
Yes.
And that letter deals to a certain extent in detail with the issue of the abusive process.
Yes.
And at the end, after dealing with that aspect, it seems Mr. Mche and the team, in the last paragraph, they stated, I must inform you, therefore, that I'm unable to accede to your request to withdraw the charges against your client. I would also like you to address me as to what weight can be put on the contents of this letter, because the decision that is reflected here contradicts the decision that was taken by Mr. Mche about 2 days thereafter or soon thereafter.
And we certainly will deal with that as we turn now to deal with the nature of the abuse.
Okay.
I made the general observation before turning to what was the abuse, to remark that the abuse for all effective purposes in no way affected the third respondent. And to the extent it did, it probably suited him in as much as, and this may be speculative, in as much as he...
Machine. Is a machine recording?
No.
Pardon?
It's fine.
It's freezing. Can we continue, or do you need to get somebody to look at the machine? Is it fine? Is it okay now? Okay. Thank you. So sorry for the interruption. You may continue, Mr. Rosen.
And to the extent that the question of the timing, or particularly the delay in service of the indictment, affected him at all, it very probably suited rather than prejudiced him. And it's in that context, and we'll be coming back to it, that we make the point that insofar as the abuse of process pivots in no small way on some form of injustice unfairness, even if it's not fair trial implicated, that connection is absent in this case, and we'll return to that. And then the question arises, what is the abuse? It's said to be in political interference in the timing issue, as evidenced in the intercepted conversations between Mr. Nguka, former national director, and Mr. McCarthy, the head of the Directorate of Special Operations, the DSO. And we in our heads have divided that analysis up. We've said that, first of all, there is an inquiry into what happened over the period from 1 December 2007 up to 6 December 1 November 2007 up to 6 December 2007. The latter being the date upon which Mr. Mshe advised Mr. Downer in a telephone conversation on that day that a decision had been taken not to announce the prosecution of President Zuma until after Polokwane. And if one has regard to what was occurring over this process, if one can turn to the chronology that we've prepared, one sees in the decision to prosecute President Zuma that on the 12th of November 2000, well, in fact, it's on the 1st of November 2007. This is shortly before the Supreme Court of Appeal decision in the search and seizure cases was to come out, but clearly in expectation of a favorable outcome, that on the 1st of November 2007, and I'm referring to item 10 in our chronology, if your justices have that in front of you, you will see that Mr. Mshe and his deputies met the prosecuting team to assess the readiness to proceed against President Zuma. And there was a decision, some discussion at that stage as to who should, in law or at least in form, take the decision to prosecute, and that appeared to be principally directed by the view that the NDPP should not take the decision or formally take the decision to prosecute, because if later representations were to be made in terms of Section 179(5), to give that process proper respect and application, the National Director shouldn't have made that decision. And thereafter, on the 12th of November, there was a further meeting where Mr. Mshe met his deputies, and the question of postponing until after Polokwane didn't arise, and again it was a question of merely who was to take the decision to prosecute. And thereafter, on the 14th of November, item 18, there was a meeting to resolve the question of proceeding with the authorization of the racketeering charges under poker. And on the 20th of November, item 20, the prosecution team submits an application for the centralization of charges. And on the 21st of November 2007, item 22, Mr. Dana and Mr. McCarthy agreed that the finalization of the indictment was to be left to the prosecuting team. On the 26th of November, Mr. Moshe and his deputies met, and that's item 23, to discuss the prosecution and the need to inform the minister. And on the 27th of November, item 25, Mr. Moshe met his deputies regarding outstanding aspects of the prosecution with a briefing from the prosecution team, and it appears that ultimately this briefing appears to have taken place, and it's common cause that effectively on the 29th of November at item 26, this represents the day in which the prosecution was finally approved. And on the papers, it's common cause that represents the day in which what is now recognized as a corporate decision to prosecute was taken. And the point that bears emphasizing, of course, if one has regard to the overall context of this, and particularly the meetings and steps to which we've been referring, there really was no real, or there was no real need for any consideration of whether to prosecute. That decision had been made in the wake of the decision of Squires in Natal in the Sheikh prosecution and the subsequent accumulation of evidence and documentation, and then fortified by the anticipated and then realized decision of the SCA in early November 2007 that material could be utilized. So really, in our submission, it appears that case against the President had steadily increased in its strength and its potency. And by the time that these meetings took place in November 2007, it was a question of putting in place the steps taken to progress that prosecution. The poker charge, the authorization by Mr. Moshe of the poker charges, the finalization of the indictment, authorization for centralization, and the like. And
in your opening remarks, you did state that the first respondent did now agree that the decision was a corporate decision.
Yes.
That's not an issue anymore.
yes. I am referring to this and to this sequence of events to emphasize the point that one will ultimately have to assess the McCarthy conduct insofar as the timing is concerned with the whole question of the prosecution of President Zuma and whether, in fact, it bore any significant relationship to that process which culminated in the decision of 27 November. And that's why I've taken the court through that.
I just ask, the tax question was also then dealt with in November for the first time?
Yes.
With the poker
Yes.
application?
Yes, that's correct.
May I raise one question? On page B, 130, it seems that is the reasons.
Yes.
It seems Mr. Mche rests his decision of abuse solely on the question of the timing of the service of the indictment. Am I correct to say that? Or could there be other alleged conduct of McCarthy which, apart from the timing of the service?
Mr. Justice Mockley, you're quite correct that at page 130, which is B130, Mr. Mche's reasons, he states in terms that the conduct consists in the timing of the charging of the accused. And it's in that context that the NPA has accepted that in evaluating the rationality of that decision, one must accept that was what the conduct consisted of, and it was that reason as articulated in JS10 that must be evaluated.
I think the time to adjourn here and resume
As the Well, I'm not getting any brutal assaults yet. I'm in a sort of
we proceed, Mr. Rosenberg?
The 3rd of December 2007, I reviewed the steps which taken place in regard to the institution of the charges and service of the indictment. On the 3rd of December 2007, Mr. Mshere reported to Minister Manda in terms of Section 33 of the NPA Act. That report appears in D of the record, file D of the record at page 364. And at page 365, paragraph 5 of that report, Mr. Mshere says, we last reported that the only real obstacle to the decision on whether to recharge was the search warrant appeals. As these have now been determined in the SCA, no real obstacle to the decision remains. And in paragraph 6, it remains my view it would be unnecessary and undesirable to wait the outcome of any further appeal to the CC. And at page 367, D367, paragraph 7, Mr. Mshere says, in all the circumstances, I consider it's now appropriate that the decision to charge the suspects on the charges indicated below should be made as it has been. And page D369, paragraph 19 of the report, Mr. Mshere says the prosecution team gave a final briefing to the acting NDPP and the deputy and acting deputy NDPPs during a meeting of 29 November 2007. They confirmed their earlier recommendations concerning the prosecution of the third respondent and the two tint companies. Paragraph 20. In accordance with all of the above, the investigating director, Directorate of Special Operations, Justice, as you will be aware, that is Mr. Mngwengwe, an investigating director in the DSO, with effectively the position of a DPP. He formally took the decision. He signed the indictment, as you will be aware, and the memorandum or report to the Minister says, in accordance with the above, the investigating directorate, in consultation with the head DSO, me, that's Mr. Mshere, the other deputy and acting deputy NDPPs, and the prosecuting investigative team, has decided to institute proceedings against the third respondent. And thereafter, if we may return to the chronology that you have in front of you, you will see under item 30 of the chronology, the decision to prosecute the third respondent, that on the 4th of December 2007, Mr. Mshere raised the possibility, or he spoke to Mr. Zuma, and he raised the possibility of postponing the announcement with Mr. Zuma, with Mr. Dana. And a helpful document in Record D is Mr. Dana's recapitulation of the events over this period by reference to his notes and his diary, which one sees at D57. It starts at D56, and he charts and records everything that happened over this period. And on the 4th of December 2007, you will see there at item 15 that Mr. Mshere raised the possibility of postponing the announcement with Mr. Dana, indicating what had still to be done. On the 5th of December, returning to the chronology, one knows that Mr. Mashe spoke to Minister Mabandla. One knows from subsequent documentation in the bundle that Minister Mabandla was concerned with the security and stability implications of serving the indictment on the third respondent prior to Polokwane. And we'd make the point that that's a legitimate concern. And it was a legitimate concern that a number of people had, and it bore no relation to political machinations or political manipulations. And although, for example, Mr. Downer emphasized in his memoranda that it should be solely a prosecutorial decision, and the kind of concern that the minister had, which was not directed towards advantaging any particular party, but was directed towards issues of stability and good order, even to that extent, as Mr. Downer contended, even with the best will in the world, it should be effectively a narrow prosecutorial decision. But we make the point that Minister Mabandla had that concern, and we know that she met with Mr. Mashe on the 5th of December. And on the 6th of December, turning to item 33 of our chronology, and also as reflected at D58, Mr. Downer's recapitulation, we know that Mr. Mashe spoke to Mr. Downer. And Mr. Downer's record of that reads as follows from D58. Mr. Mashe, says there's a 90% possibility that he will decide to prosecute in accordance with the draft. Para 16, D58. He says there's a 90% chance that he will decide to prosecute in accordance with the draft indictment. He'll only make the announcement next year. We can file a supplementary affidavit for the CC when this is done. Justice, as you'll recall, that there were those in the NPA who felt, certainly amongst the prosecution team, that it would assist, and for reasons which aren't altogether clear, but it would assist in the application for leave to appeal, which President Zuma was making to the Constitutional Court in relation to the SCA's judgment on the search and seizure. It would assist in the answering affidavit of the NPA if it were able to say that we've proceeded, we've implemented, we've served the indictment, presumably to try and show some kind of reliance and implementation on what had been made available. It's not entirely clear why it was considered important, but for whatever reason, that appeared to be at some stage the prosecution's team's motivation for trying to push through the service of the indictment. And on the 6th of December, returning to D58, as I said, Mr. Mashe indicated that in this connection, a supplementary affidavit for the Constitutional Court application could be filed next year. Mr. Downer records very frank and good-humoured discussion ensues. NDPP mentions that he does not wish to be seen to be interfering in the Polokwane process. He has taken account of President Mbeki's speech where the President called for calm and stability prior to Polokwane. The NDP consulted with the Minister the previous evening. The decision not to announce the decision to prosecute was his alone and no one else's. Mr. Downer informed Mr. Mashe that in his opinion this was an incorrect decision. Returning to the chronology, on the 7th of December 2007, item 36, Mr. McCarthy, who at that stage, as it appears from certain of the intercepted conversations, was on leave until the 10th of December 2007, Mr. McCarthy spoke to Mr. Downer and indicated that he hadn't been consulted on the decision to delay. The next step in the process is on the 14th of December, where Mr. Mshe signed the poker authorization, and then centralization applications had to be dealt with, and one knows that the indictment itself still had to be finalized. It was ultimately checked by and approved by Mr. Mgwengwe some time later. Now, perhaps against that background, before turning to the conversations in question, if I could return you back to item 25 on the chronology of the decision to prosecute. On the 27th of November 2007, Mr. Mshe met his deputies regarding outstanding aspects of the Zuma prosecution, and one sees the minutes of that meeting at WH 56-376, and it is of some importance. It's in volume 5, and if one turns to 376, one sees that's volume 5, page 376, WH 56. These are Ms. Matska, who is in the office of who was in Mr. Mshe's office, her notes of that meeting, and you'll see at page 376 there's a query from Mr. Ramaiti, Dr. Ramaiti, at the 6th bullet point down, will they be ready in February? And if one has regard to the items that were raised, and we've summarized them, all the issues that were having to be considered and having to be completed, it appears that at this stage there must have been real uncertainty as to when, in fact, all of these steps could be done. The poker authorization, the centralization of charges, the other aspects that are referred to here. It certainly would appear that whereas Advocate Breitenbach and Mr. Downer at some stage had met and had considered that the finalization of the indictment was doable by the 11th or the 12th of December, having regard both to the issues raised at this meeting as well as to the unfolding of the further steps thereafter, that it is not at all clear that despite the strategic goal of having the indictment served by the time the Constitutional Court papers were submitted, that could have been achieved. If we turn to the conversations that took place between Mr. McCarthy and Mr. Nguka, they span the period for November well, first of all, one can have regard to the conversations over the period for November 2007 to 6 December, being the date upon which the decision to postpone service was taken. And those conversations appear in portion B of the record. I'm not going to take the court to each of those conversations. They're dealt with in our heads. I'm going to give a brief summary of what we believe those conversations over this first critical period indicate. The period up to 6 December 2007, when the decision was taken to postpone service of the indictment till after Polokwane. Now, there were 7 conversations over this period. 2 of those conversations were between Mr. McCarthy and businessman Mr. Mzwi Kumalo. 5 of those conversations were between Mr. McCarthy and Mr. Nguka. The first conversation was on the 7th of November 2007. One sees that in record B, page 3, if you wish to turn there. This was a conversation which related to a Business Day editorial of the 6th of November, and there is where the Business Day editorial speculated apparently as to the strategic pros and cons for the competing parties as to service or not of the indictment on the third respondent before Polokwane. There are some references in that conversation to the man. It speculated that that reference to the man was apparently Mr. Ronnie Casrels, who'd at some stage expressed a view that charging the third respondent before Polokwane would lead to chaos. The second of those 5 conversations, it's at B5, nothing of consequence was discussed in that conversation. The third conversation was on the 9th of November, B7. We've rehearsed each of these in our heads. I'm just going to go through them quite briefly.
So clearly, in respect of these conversations, there's a dispute as to exactly what do they mean between the applicant and the respondent.
Yes.
There's a dispute of fact.
Well, there's a dispute with respect as to interpretation. The conversations are what they are.
Dispute of interpretation,
Yes.
rather. Yes.
Yes, so you can have regard to the conversation. You can read the conversations we have submitted in our heads of argument, and I am summarizing that now, that on any reasonable construction of these conversations, for example, that the second conversation, you can read it, I'm not going to take the court through it, nothing of significance relating to the timing was discussed.
Wouldn't the court be the appropriate forum to sort out this issue of interpretation?
Yes, of course. Of course.
Because we have read the conversation.
Yes. So I'm going to move through that quite quickly. My submission is that the second conversation, and this is in our heads, the second conversation contained nothing of significance. The third conversation of the 9th of November, there's a reference by Mr. Nguka to a possible appeal by President Zuma, but nothing else of any significance. The fourth conversation between these two parties, which you see at B10, Mr. McCarthy indicated he was on vacation at his apartment in Cape Town. There's some general reference to the results of the provincial nominations for the ANC presidency. There's possible reference to Mr. Nguka seeing President Mbeki. What there is in that third or fourth conversation is an indication. At the end of that conversation, Mr. McCarthy stated to Mr. Nguka that he'd taken or followed Mr. Nguka's advice up to Friday, but then he'd received a strong memorandum to say charge and get on with the matter. That appears from that conversation. This description of receiving a strong memorandum or indication from the prosecution team that they were going to charge and get on with the matter accords with Mr. Downer's suggestion to Mr. McCarthy when they spoke, and the approach that Mr. Downer adopted generally, that in fact there should be no delay. We know that in fact on the 12th of November 2007, Mr. McCarthy had spoken to Mr. Downer and had raised the possibility of delaying the prosecution until after, in service of the indictment, until after Polokwane, and Mr. Downer had been quite firm in saying that that was not desirable, and that seemingly was the end of the matter. So, as far then as the fourth conversation of the 26th of November 2007 is concerned, that was communicated to Mr. Nguka. Of some significance is that Mr. Nguka, who on the version of the NPA was apparently pulling the strings and giving the instructions, didn't respond at all. He was told by Mr. McCarthy that the prosecution team had taken the view that the matter must just proceed without any delay, and Mr. Nguka didn't respond at all and said, no, well, come on, you can do better than that. The fifth conversation at this period was on the 6th of December 2007. And it was apparent that he was on leave still at this time, and that he wasn't really involving himself in work aspects or work issues. So what can one make of these conversations? Perhaps one can draw the following conclusion. There's some indication that McCarthy may have initially followed the view, or been of the view, that the prosecution could be reinstated immediately, and Mr. Nguka may have been of the view that it would be desirable that at least the reinstitution shouldn't take place until after Polokwane. It may be that when Mr. McCarthy approached Mr. Downer on the 11th of November, I think it was 2007, and it may be that, well, certainly when he did approach Mr. Downer on the 11th of November 2007, he was seemed to have been persuaded by the view that by the prosecution team that the criminal proceedings should continue immediately. And again, then, if one has regard to the conversations between Mr. Mshe and Mr. Downer between the 4th and the 6th of December, and has regard to the interaction between Mr. Mshe and the minister over that period, his meeting on the 5th of December, that Mr. Mshe was persuaded and made the decision that the service of the indictment should be held back. And it's not altogether clear to what extent Mr. McCarthy played a significant role in that. So much for the telephone conversations over this period. The telephone conversations which took place over the period 7 to 18 December 2007, there were 17 conversations that were transcribed in that period. We've dealt with them on the basis of themes, what broadly they addressed. We've made the point in our heads that the first theme that they dealt with was this question of when the NPA's papers in the Constitutional Court were going to be filed. The NPA were required to file by the 14th of August, December 2007. And what appears from these conversations that at various points Mr. Nguka sought to encourage the expedited filing of the answering papers in the Constitutional Court proceedings in the hope that these would somehow elicit some negative publicity for the third respondent. To the extent that Mr. McCarthy indicated some willingness to assist, really, if one has regard to what was actually happening, he had no ability to deliver at all or take that matter any further. One knows what was happening on the ground. The second theme is what we've referred to as McCarthy and the arrests at Polokwane. There's some indication in certain of the conversations that McCarthy suggested that in somewhat grandiose fashion that he felt like going to Polokwane and charging the third respondent there. We'd suggest that Mr. McCarthy would have known that he had no power to make good that threat. The third theme in these conversations is in connection with a supposed conversation that Mr. McCarthy had with the editor of the Mail and Guardian, Ms. Haffergy, the intimation being that this could have been at the behest of President Mbeki. In the papers you'll see that Ms. Haffergy robustly denies Mr. McCarthy's account of the conversation. She says it's false and designed to bolster his own sense of self-importance and his sense of from rubbing shoulders with important people. The fourth theme that emerges in the conversations over this period is that relating to an 8-page fax that we know was sent by Mr. McCarthy to Mr. Nguka on the 14th of December 2007. There's no indication from the record what this fax contained.
You've dealt with that aspect in detail in your heads.
Yes.
You can just indicate to us what you think.
Yes, I'm not going to take that any further. And the remaining themes was McCarthy and Mr. Davids' discussions regarding Mr. Hofmeyr and a possible meeting that was to be held between Mr. McCarthy, or took place between Mr. McCarthy and Mr. Mbeki after Polokwane, which on the papers and according to Mr. Nguka, who was in his response, took place in relation to Mr. McCarthy's proposed departure to the World Bank. And the final group of conversations are those which are 13 conversations which were transcribed after the results in Polokwane were announced on the 18th of December. And for the most part, they related to expressions of disappointment at the outcome, whether it's Mr. Nguka, Mr. Kumalo, or Mr. McCarthy. They related to the possible extrication by Mr. McCarthy from the NPA, and they related also finally to this meeting between Mr. McCarthy and Mr. Mbeki, which took place on the 21st of December. And the final conversation that requires any attention is the fairly lengthy conversation between Mr. McCarthy and Minister Mabandla on the 29th of December. And the main topic of that conversation, you'll be aware, was Minister Mabandla's proposed response to Mr. Zuma's support, President Zuma's supporters who were claiming a political conspiracy. So, in those circumstances, we make the submission that the nature of the conduct being the political interference in the timing of the service of the indictment was limited and insignificant, essentially. The extent to which there was political manipulation as represented in these intercepted phone calls is not particularly significant. To the extent that it took place, its actual influence on what happened is equally insignificant, or relatively insignificant, in the broader scheme of things. What we see is that at the end of the day, the service of the indictment was ultimately took place on the 28th of December 2007. It's not at all sure when this service would otherwise when this indictment would otherwise have been served, whether in fact it was possible and it would otherwise have been served prior to the 16th of December 2007, and it's also unclear the extent to which considerations relating to security and the concerns that Mr. Mshe and the Minister shared regarding service before Polokwane played in that decision. So, that being the case, in the context of a decision to prosecute, which had been developing for years as the prosecution strengthened and its potency increased as, for example, the SCA affirmed the search and seizure process, and as in the course of Mr. Sheikh's criminal trial, further evidence and material was produced. That decision was one which was taken over a period of time, and certainly in November and early December 2007, one was dealing only with the question of when the prosecuting team would be ready to serve that indictment. And if one were to accept that Mr. McCarthy's conduct in any way influenced, and accept that we can for present purposes, on that assumption, if one were to accept that Mr. McCarthy's conduct in any way influenced Mr. Mshe's decision or the decision of the body to delay the service of prosecution, the service of indictment, it really was insignificant in the broader scheme of things. And that is why we made the point earlier, and we'll be dealing with it in more detail at the later section of these submissions. That's why we made the point earlier that the abuse of process cases are essentially dependent on and pivot on this concept of some fairness or injustice or breach of human rights or an accused's entitlement to fairness outside the fair trial procedure. And we've said that if one has regard to what happened here, the conduct in no way played any significant role as far as the third respondent's rights to fairness or his rights generally were concerned. The decision to discontinue the prosecution is what we must now turn to. And if one goes back to the chronology, one sees that under item 12 on the 10th of February 2009, written representations were received from the third respondent. On the 20th of February 2009, that was followed by oral representations that were made. On the 3rd of March, the prosecuting team prepared a memorandum to Mr. Mshe dealing with those written reps and the oral reps. That appears in the record at volume C, page 1, and it's important to perhaps then contextualize the letter which you referred us to, Mr. Justice Ledwaba, the letter to Mr. Halley, which I said I'd come back to, which it appears at D7. On the 3rd of March 2009, the prosecuting team's memorandum appears at page C1 and following. And at this stage, at page 11 of that bundle, paragraph 10, the prosecution team recommended that the representation should be declined. This is, of course, before the transcripts had been presented to Mr. Hofmeyr and Mr. Mizanyati. Paragraph 12, finally, the NPA must not discount the value of the forensic successes that it has achieved in this case, despite setbacks that at times have seemed insurmountable. The SCA and the CC have also gone to some trouble to appraise the issues in a sober fashion, and the NPA has emerged with merit. To accede to the representations in a summary manner would abandon all the ground won by the expense of extraordinary effort and resources, and with the approval of the highest courts in our country. A retreat for no good reason at this stage would not be explicable, understandable, or defensible. And it was in that context that the prosecution team prepared and recommended the dispatch of that draft letter to Mr. Halley, setting out why the representations should not be adhered to.
This memo by Downer was done a month before the decision was taken not to prosecute.
Yes. This is after, in relation to the written and oral reps of 10 and 20. Returning to our chronology, item 16 of the decision to discontinue, between the 6th and the 16th of March 2009, the third respondent's legal representatives presented Mr. Mizanyati, who was at that stage the acting head of the DSO and Mr. Hofmeyr with certain transcripts of intercepted conversations. On the 18th of March 2009, the NPA management team, and that's item 17, the NPA management team informed the prosecuting team of the nature of the oral representations, and it's agreed by everyone as to the merits of the case. And on the 20th of March 2009, the prosecution team prepared a memo to the NPA management, which one sees at C30. At that stage, at C28, in fact, at that stage, the prosecuting team had taken advice from Advocate Trengrove on the matter, and at C30 it deals with events which had taken place subsequent to that meeting on the 18th of March to which I've referred. And if you were to turn to C30 paragraph 8, it's recorded that Mr. Hofmeyr, together with Advocates Dana Steinberg-Beloy, met with Trengrove SC on the afternoon of 18 March. Mr. Hofmeyr took Advocate Trengrove through the essence of the oral representations. The team members presented to him some of the considerations for and against acceding to the representations. We all expressed our sense of dismay, our dismay and sense of betrayal. Of course, at that stage, only Mr. Hofmeyr and Mr. Mizanyati had listened to the representations. Paragraph 9, Advocate Trengrove advised that in essence the shared decision to prosecute lay at the heart of the fairness of the trial. If this remained defensible in that it was untainted by allegations of political conspiracy and based on evidence that is also so untainted, then the decision to prosecute should remain. And in paragraph 10, it appeared that advice to the same effect was obtained in a consultation between Mr. Dana and Advocate Breitenbach on the evening of the 18th of March, where Advocate Breitenbach advised that if the shared decision was untainted, this provided basis upon which the trial should continue, and he expressed more strongly his reservations about the relevance, legitimacy and coherence of the allegations made in the oral representations.
The letter was actually attached to that.
I in fact understand that that letter was attached to that memo of the prosecuting team, the letter which appears at D7. Thereafter, between the 20th and the 24th of March 2009, the prosecuting team interviewed Mr. Nguka twice. He wanted to listen to the tapes, but wasn't permitted to. And on the 30th of March, there is a meeting between Mr. Mshe, his deputies, Mr. Mngwengwe, and the prosecuting team regarding the oral representation. The notes of that meeting appear, amongst other places, at Annexure WH1, page 331, which is at volume 4. Those are notes taken by Ms. Matske of that meeting, and there are also some helpful notes to which I will be referring, taken by Mr. Miznyati, which appear in volume C of the record at page 82. And just get volume C, 82. If one has regard to what occurred at that meeting, it was agreed by all the parties that the merits of the case remained strong, that, and perhaps one could most usefully refer to Mr. Miznyati's notes in volume C of the record at page 82, where after discussing the response from Mr. Nguka, in the middle of the page, it's C82, Mr. Hofmeyr then went through a narration of the tapes that he and Mr. Miznyati had heard. There's plus minus 100 calls.
Excuse me, I'm not with you. You said C82.
C82.
In the middle.
Volume C of the record, page
Yes.
82.
Yes.
Above, Justice Rob, do you see the share quo vadis towards the foot of the page?
Yes.
Just above that.
Okay.
Note, Mr. Hofmeyr went through a narration of the tapes that had been heard. There were apparently 100 calls in 6 months. These are ugly tapes and more explicit. According to Mr. Hofmeyr, this showed apparently the mendacity of Mr. Nguka. Mr. Mshere apparently then said, well, or indicated what the way forward was. There was some concern regarding the utilization of the tapes that had been received, and he was unsure as to whether or not these should be followed up with the NIA, page C83, the third paragraph, the fourth bullet point. Mshere says he's not keen in following on the NIA tapes. Attaching a lot of weight on the NIA tapes would be perceived as having gone out of our way to assist JZ. And thereafter, towards the foot of the page, it appears that the prosecuting team were released, the deputies remained behind. Mr. Mshere indicated that by next Wednesday, the 1st of the 4th, 2009, we should make a decision. We'd point out it's not altogether clear why there was this pressure to make that decision by that date. The court will be aware that, in fact, for example, at one stage it was indicated in these conversations that it was important to get the input of both Mr. Nguka and Mr. McCarthy as to the inferences that could be drawn from these tapes, as to suggestions that were made at certain stages, that President Mbeki was also involved and was behind the curtain, to use the phraseology employed by Mr. Mshere in one stage, and so on. And the court will be aware that, in fact, it was only the day, I think it was the day after the decision was made, the 2nd of April 2009, that a request was sent to Mr. McCarthy to answer the list of questions that were presumably considered important and relevant to the exercise of the discretion. Mr. McCarthy had earlier responded to an earlier letter by indicating that he wished to have details of the dates of the conversations, to, I think, to see the tapes and who the parties were concerned. On the face of it, reasonable responses, but it was in fact, as I say, only a day after the decision that a focused request in the form of 22 questions was sent to Mr. McCarthy. In any event, for whatever reason, Mr. Mashe felt pressure to make a decision, or felt it important to make a decision by Wednesday, the 1st of April. And over the page at C84, one sees it recording, and it does appear from the notes to which we refer, that Mr. Hofmeyr was the one who was arguing forcefully that one couldn't proceed. For the most part, if regard is had to these notes, it would appear that all the other parties broadly appeared to support the view of the prosecution team that the matter ought to and had to proceed. So that was the meeting of the 30th of March. It was on the 31st of March, item 29 of our chronology, that Mr. McCarthy responded, requesting more information regarding the intercepted communications. And on that day, the 31st of March 2009, item 30, it appears that Mr. Mashe, the deputies, and Mr. Ngwengwe met, and the meeting continued in the absence of the prosecuting team. Again, if one refers to Ms. Matzke's notes at WH22, page 342, which again is volume 4, one sees that page 342, Mr. Ngwengwe was included in order to consult with him, and there was some general discussion of the question of ulterior motive jurisprudence and the impact of political manipulation in the light of a watertight case against Mr. Zuma, and it was agreed at that stage that although Mr. Mshe had seemingly been disinclined to listen to the tapes, he was going to listen to the tapes that evening. And listen to the tapes he did that evening, and on the 1st of April, he announced to the NPA management team his decision to withdraw the prosecution. And that meeting, it's an important meeting, obviously. One sees that, the minutes of that, or notes of that meeting rather, taken by Ms. Matzke at WH25, page 345, volume 4. And also, if I could ask you to turn at the same time to Mr. Miznyati's notes of that, which are in B of the record 75. Can I get that from you as well? Just hold Miznyati's notes for me. And perhaps we could start with Mr. Mznyati's notes at B75. In the middle of the page, Mr. Mashe, or perhaps if I could start at the top. Mr. Mashe said he'd received a response from Mr. McCarthy. He needs inter alia all the necessary and relevant facts in relation to the recordings, and he sets that out, and it's then recorded that the NPA had sent Mr. McCarthy the 25 questions. We know that they hadn't sent them at that stage, but they were obviously preparing to send them at that stage. We then went to visit the NIA last night. That would have been Mr. Mashe and his deputies. And Mr. Mashe says, after listening to the tapes, and I'm reading from the middle of the page of those notes, after listening to the tapes, he can't separate Leonard's involvement. He got angry. He can't go on with this case. He's decided to drop the charges. We just need to prepare the motivation, and how do we substantiate this decision? He says we have sufficient information to explain our decision. He goes on to say he has no doubt that the President may have been a player behind the actions. He then goes on to the inferences that he draws about the involvement of the President. That refers to one of those conversations where Mr. Nguka had indicated to Mr. McCarthy post Polokwane, you're on your own. And the comments of various deputies are there reflected. The third bullet point from the foot of that page reflects Dr. Ramaiti saying that there must be a valid and sound basis, which he's not sure we have. This needs a little bit more research, a lot of research. And then over the page at B76, it's proposed that we only use the Hully tapes and not the NI tapes. That's of no real relevance. Mr. Mashe sort of agrees with me. And
excuse me, the gentleman
where's the Matska? The Matska tape.
for the interruption, you may proceed.
Thank you, Justice Ledwaba. If one turns to Ms. Matska's notes of that meeting at WH25, page 345, volume 4, she too records the response that had been received from Mr. McCarthy indicating what he required in order to respond more fully, and the option that's suggested by Mr. Hoffman is to provide a set of questions to him. And then at the top of page 346, Dr. Ramaiti says, or appears to have said, our approach is based on the manipulation. Are we suggesting that in the so-called manipulation is Mr. Nguka and Mr. McCarthy involved and no others? And the suggestion is, well, if we're going to draw an inference that this conspiracy or manipulation goes more widely, well, don't we have to request responses from the people involved, not only the presidents? We need to provide a very clear background.
The President referring to President Jacob.
Yes. Mr. Mashe seemed to seemed to vacillate in his approach. We've seen earlier in the notes of Mr. Mzanyati his suspicion that the President Mbeki, was behind the curtain. He then says, well, here at a later stage of this meeting, well, nowhere in the tapes we can't say anything with regard to the President. Mr. McCarthy and Mr. Nguka are the main players. And it's then said that by Mr. Mzanyati that this raises a very important issues. And if you are talking about manipulation, there must be some kind of clarity about who the manipulating parties are. And does it in fact mean that President, as he says here, President Mbeki and Minister Mabandla are implicated? And then at the foot of the page, Mr. Mshe then says, well, I have no doubt that it might be a case of President Mbeki working behind the curtains. Over the page, at page 347, Dr. Ramaita, who kept sounding words of caution, said, we're trying to get the full story at face value. Mr. McCarthy abused the process. How and what way did he abuse the process? And if so, did he and Mr. Nguka act on a frolic of their own, as he put it? Mr. Mshe at that point seemed to indicate, well, we should forward the questions to Mr. McCarthy with a timeline. There's discussion of the tapes then. So that was all the prelude, covered in slightly more detail than is covered in Mr. Mzanyati's note. This is all the prelude, and then a discussion of the tapes that had been listened to the previous evening. And then, if one can move forward to page 352, in an echo of what one sees recorded in Mr. Mzanyati's note, Mr. Mshe indicated that he listened to the tapes. I've come to the conclusion that whilst we were honestly working on this matter, I can't go on with the matter. Seriously decided to drop the charges. We need to work on the motivation. We need to look at the release and substantiate it. We have sufficient to say the process was influenced. I want to exclude the minister. I have no doubt he was moving behind the curtains. If one traces back that metaphor, that would appear to be the President. And then there is discussion of, well, if that is Mr. Mshe's decision, in principle, we get a support it if we have to. Page 353. The sixth last line, Mr. Mzanyati again emphasizes that the packaging of the reasons will be crucial. And Mr. Ramaiti repeats, you're going to need a firm and sound legal basis. You're more worried about the legal arenas and need a sound and firm legal basis. So that is what we have on the minutes of, or what occurred on the meeting of the 1st of April 2009. And we submit that what appears from this is that the decision of Mr. Mshe was an impulsive decision. It wasn't at that stage a reasoned decision. We would submit it wasn't at that stage a rational decision, backed by any reasons. It was a decision which reflected his own sense of betrayal and anger and outrage over the McCarthy conduct. We would submit that as at 1 April 2009, unreasoned and impulsive as it was not a rational decision. The reasons were worked out and developed. Or articulated and appeared in JS10, the press announcement of 1 April 2009. 6 April 2009.
In essence, your submission is that a decision was taken and thereafter reasons were put together.
Well,
do you understand it well?
Well, a decision was taken. In a sense, the reasons that were provided on the 6th of April represented Mr. Mache's reasons. They hadn't been formulated or considered in any particular way on the 1st of April, other than we would submit that there was the sense of outrage and betrayal, and we say that the decision in those circumstances, made prior to consulting or getting further information from possibly involved parties such as Mr. McCarthy, was taken prematurely, it was taken impulsively, and if one then has regard to the reasons as developed, and they may be accepted to be the reasons lying behind that decision when an attempt was made to articulate the reasons for what had taken place. Those reasons, in fact, buttress the submission that we've made. We've indicated that if one turns back to Annexure JS10, what one sees there is an emphasis on Mr. Mache's personal sense of outrage at what had occurred. He concluded that this amounted to an abuse of process. His reasoning in JS10 appeared to be that because of the sense of disquiet and the sense of disapproval that this conduct evoked in him and in any right-thinking person, presumably, it constituted or qualified as abuse of process. In the first instance, we say that that is not sufficient for the purpose of applying the doctrine, or that concept of abuse of process. Returning to Latif, what was required of Mr. Mache was not merely to conclude that this conduct provoked a sense of outrage in him. What he had to turn his mind to was the second question, which he never did. And the second question is, did this abuse, or was this abuse of such a character that in weighing up policy versus justice, one had to conclude that this was such an egregious contravention of the rule of law or President Zuma's rights or fairness generally, that it warranted the discontinuation of the prosecution. We have indicated in our submissions that in the papers in this matter that the decision was fundamentally irrational. And why we say it was fundamentally irrational was, in the first instance, we say that in weighing up or in evaluating the abuse question, the decision maker had no regard, or insufficient regard. We would in fact say had no regard.
Now, on the, I still need to press you on this one. The record reflects that they met on the 30th, not
Yes.
so, to listen to the tape.
No,
I'm talking from their point. I'm not, just, let's cut the other things.
They met on the 31st,
On
and they
the
listened
31st, to listen to the tape.
and they listened to the tapes that
That was the
evening.
day before he took the decision.
Yes.
Now, after listening to the tape, was there a discussion about their views concerning what they've just heard?
No, well,
there any record
there's
of
no
that?
record of that. What
And they did not take a decision on the 31st.
Well, what we have is that the notes of the meeting of 1 April reflect clearly Mr. Mashe indicating, I have taken a decision after listening to the tapes last night.
Was there any discussion of what they've heard in the tape? I take it the people who were at the meeting of the 31st listening to the tape were more or less the same people on the 1st, not so. Was there any occasion before he made the announcement or after he made the announcement where the views of other members were heard about the impressions on the content of the tape?
As we understand what is put up in the answering papers as buttressed by notes and minutes of meetings, there's no indication of Mr. Mashe and his deputies caucusing and discussing and coming to a joint decision on that score. We have merely the record of the discussions on the 31st, no decision, and we have the record of what happened on the 1st, and there's clearly an indication of an announcement by Mr. Mashe to his deputies and everybody else that I have decided I can't go on. And the response there appears to be, yes, I've been referred to page 249 of the answering of the answering affidavit of Mr. Hofmeyr at page 200 and paragraph 268 to deal further with this point raised by Mr. Justice Mochley in paragraph 268, page 249, volume 3. At page 2, paragraph 266, Mr. Hofmeyr says, until the evening of 31 March 2009, only Ms. Nyati and I had listened to the recordings. Once the NIA confirmed that we could make transcripts of the recordings, Mashe decided it was time for him and the deputies to listen to them too. This happened on the evening of 31 March 2008. On the following day, 1 April 2009, Mashe met with the deputies and with Mr. Mngwengwe. It is evident from the record of that meeting that he was disturbed by what he had heard on the tapes. Now, Mr. Hofmeyr would have been present there as well. And it's evident from the record of that meeting that he was disturbed by what he'd heard on the tapes until the night before, when he'd listened to the recordings before, he'd relied upon reports from Ms. Nyati and me to tell him what the recordings contained. He told, paragraph 268, he told us that listening to the records had made him angry. He informed us that he could not go on with the case and that he had decided to drop the charges, in other words, to discontinue the prosecution. Yes.
Mr. Rosenberg, but if you read that, it's clear that he says there it was my decision to discontinue.
Yes.
Is that correct?
Yes.
Because that's how I understand it. I'm not
Unambiguous.
Yes.
Do we have an affidavit from Mr. Mche specifically dealing with this aspect as to how the decision was taken,
We have an affidavit from Mr.
other than the confirmatory affidavit?
confirmation confirming this account.
But there's no confirmatory affidavits from the other NDP parties. Yes.
But for present purposes, the answering affidavit is clear and appears to speak fully in line with the documentation. 269, Mr. Moshe felt betrayed by Mr. McCarthy. Once he heard the recordings, he realized to the extent to which Mr. McCarthy had manipulated people, he felt. So, the sense of betrayal and outrage articulated and felt by Mr. Moshe led him to the conclusion that this was an abuse of process of a kind which warranted the discontinuation of the prosecution. We say that that decision was irrational for certain reasons. In the first instance, we've submitted it was irrational because, in fact, he failed to take into account or pay any consideration to the factors which indicate, or the policy considerations in support of a continuation of a corruption prosecution of this magnitude and kind in particular, which had as long and difficult and significant provenance as this prosecution had. And in that regard, we say that he failed to have any proper regard, if one formulates it in a slightly different way, but with relation to this exactly the same issue, he failed to have any regard to the second question in Latif, the balancing up between the policy consideration of continuing a prosecution like this as against considerations particularly of fairness and justice to the accused. And we say that considerations of fairness and justice to the accused really hardly entered into it, or certainly didn't enter into it to any material degree, regard being had to the nature of the conduct and the limited role that that conduct played in the process as a whole. If you compare that to the kind of abuse of process which had moved the court in Bennett to discontinue, but in fact, you compare it to the kind of abuse of process which, notwithstanding the egregious nature of the conduct and the extent to which it was criticized by the court in Latif, the entrapment and so on, had been held in cases like Martin or Bennett not to warrant the discontinuation of the proceedings.
Do the papers anywhere reflect any material prejudice if the case would proceed to the third respondent?
With respect, no. Justice Ledwaba, you will be aware, for example, that in Mr. Moshe's reasons at JS 10, he made it clear that the representations from President Zuma had concentrated or referred to four aspects. The merits, the fair trial defences, the practical implications and considerations of the continued prosecution, and the policy aspects militating against prosecution. There's no implication that the fair trial defences were implicated in any way. To perhaps answer the question which you may be posing, Mr. Justice Ledwaba, in relation to any other unfairness in the sense of Latif or in the sense of Martin outside the fair trial, no. With respect, there's no indication of any unfairness at all or prejudice that may have been sustained by what, in the nature of things, was ultimately a relatively short delay in service of the indictment. I've made that point already, having regard to the time frames concerned. And in those circumstances, if anything, we've made the point, certainly in relation to holding the service over till after Polokwane, it probably suited the third respondent rather than prejudiced him.
As a follow-up to your question by my brother here, was there anything or is there anything on the papers which indicate that the conduct of Mrs. McCarthy and Mrs. Nuka tainted the evidence uncovered by KPMG in any way?
No. Nobody suggests that other than the timing, that the case against the third respondent was implicated, affected, or contaminated in any way. Those are our submissions on the question of rationality. I've got a handful of more abbreviated submissions I wish to make. If I could make them after lunch, I want to see if I can cut short the submissions in the light of the indications from the NPA as to the concessions or the approach that they may take. The submissions I was going to make may in fact be significantly shortened.
I think then this would be the appropriate time to adjourn. The court will adjourn and will resume at 2 o'clock. Elizabeth, before you proceed with your further submissions, can you give us an indication as to for how long do you think this is going to be with your further submissions?
Justice Leader, I anticipate not more than 10 minutes.
Because in terms of the note that was sent to my office, it was indicated that the applicant will be afforded the first day of submissions and respondents. The second day, but I think if you're going to finish within about 15 minutes, I assume that the respondents will be ready to proceed. And I've also I had a discussion with my colleagues. Because of the volume of papers that we've got, we'll make sure that this court is locked. You don't need to take all your files with you, and so the documents will be safe in court.
Thanks.
So be comfortable. We will also be leaving our documents. Nobody will interfere with them. You may proceed.
Can I ask turn justices to the chronology, and particularly chronology to discontinue the prosecution, page 4. We've been dealing with the decision of 1 April 2009, item 31, and on 2 and 3 April 2009, the prosecuting team addressed memoranda to Mr. Mshere. It's useful to refer to the memorandum of 3 April 2009, item 34, which appears in the record at C40 following, reference C46. And that memorandum followed up a memorandum sent by the prosecuting team on the previous day, the 2nd, which appears at page C40 and following. We needn't go to that at present, but it was, that is to say, the second memorandum was in response to certain queries raised by Mr. Hoffner related to certain aspects of the first memorandum. And in relation to, or in respect of the second memorandum, the prosecuting team in paragraph 13 of page, in fact paragraph 17 of page 49 said the following.
Before we allow ourselves to become too distracted from the main issue, we would do well to recall Advocate Trengrove's advice on the matter, and Justices, you'll recall that that advice had been given on the 20th of March and had been referred to by the prosecutors both in their memorandum and presumably in their meetings with management. Before we allow ourselves to become too distracted from the main issue, we should do well to recall Advocate Trengrove's advice on the matter, which was twofold. Advocate McCarthy's ulterior motives are not a valid reason to stop the prosecution, provided the ANDP can answer either or both of the following questions in the affirmative. Can I say that my decision to prosecute was not improperly influenced by Advocate McCarthy's improper motives? And if not, am I still satisfied with ex post facto knowledge of Advocate McCarthy's shenanigans that the decision was, on the merits, the correct one? And we have indicated that the decision of Mr. Mashere was fundamentally irrational because of the approach he took to merely conclude that the abuse in question was a sufficient affront to his sense of propriety that without more, the prosecution fell to be discontinued. In our submission, and in wrapping up this aspect of the matter, we say that the question to which a rational answer had to be given was whether the conduct justified the withdrawal of the prosecution. We say no for essentially three reasons. We've already made the point that the McCarthy conduct had an insignificant impact. These were corporate decisions, and regard being had to the timeline to which we've drawn attention earlier as to the unfolding of the steps to prosecute and the question of whether or not the indictment could have been finalized or served before Polokwane on the 16th of December, we say that in those circumstances, the McCarthy conduct had an insignificant effect or impact. But even if it is assumed, and we get to the second reason, even if it is assumed that McCarthy took or influenced the decision, why should the prosecution itself be withdrawn? This was a decision which was either taken or influenced just relating to this confined issue of timing. Why should the prosecution have been withdrawn? We must remember that the prosecution had been inevitable since mid-2005. It was a decision which Mr. Piccoli had taken prior to obtaining all the additional documents and which Mr. Mashere thereafter himself took for good and proper reasons. And it's quite frankly impossible to understand why the decision should be aborted in these circumstances, why one should abort that decision. Thirdly, the decision was apparently based upon the abusive process, and in particular, we see the most authoritative articulation of the application of the abusive process principle in Latif. And we know that Lord Steyn laid down two principles. One, it's a two-stage evaluation. Has there been an abuse which affects the public conscience? And two, does this abuse outweigh the competing public interest that those who have been charged with grave crimes should be charged? All people, we know, should be treated equally, whether in high or low office. And in that framework, one would say, well, let's accept there was offensive conduct on the part of Mr. McCarthy. It was unrelated to the decision to prosecute. To the extent it had any influence, it was related to the timing. Assuming that offensive conduct, does it outweigh the public interest that people have, that people tried with crimes or grave offences should be charged in a court of law? One, with great respect, only has to pose that question for the answer to be, this can never be. It's inexplicable and irrational to walk away at the 11th hour in these circumstances. And against that backdrop, we say that the irrationality challenge to that decision has been established and it falls to be set aside. There's just one authority before we end off on this, which has just been drawn to our attention. It essentially affirms our analysis of the Latif principle and the application of the Latif principle. It's a decision of the Court of Appeal in England in a matter of Maxwell and another versus R, 2009, EWCA Criminal Reports 2552, and a copy will be made available to the court, and I would submit that the following analysis in paragraph 57 of that judgment of Lord Hooper is of application when he discussed cases and the principle in Latif, Bennett and others. And he said as follows: Lord Brown then discussed the cases of Bennett, Mullen, Latif and the case of Loosely, all abusive process cases. In Loosely, the House of Lords held that it was an abusive process to try a person who had been lured, incited or pressurized into committing a crime which he would not otherwise have committed. Obviously, the echoes of Latif there are obvious. Lord Brown continued, and he quotes, or he is quoted, "It will readily be seen that the factor common to all these cases, indeed the central consideration underlying the entire principle, is that the various situations in question all involve the defendant standing trial where, but for an abuse of executive power, he would never have been before the court at all. In the wrongful extradition cases, the defendant ought properly not to have been brought within the jurisdiction." That's Bennett. "Only a violation of the rule of law had brought him there. Similarly, in the entrapment cases, Latif, the defendant only committed the offence because the enforcement officer wrongly incited him to do so. True, in both situations a fair trial could take place, but given that there should have been no trial at all, the imperative consideration became the vindication of the rule of law." And that's why we submit that when one applies the Latif test and cognizant of the fact that the case against the third respondent, the prosecution as a whole was not implicated, contaminated, or undermined in any way by the conduct in question, the decision to discontinue it became inexplicable. We have not dealt with the 179 argument at all at this stage in view of the indication we've received from counsel for the NPA as to what approach is being taken. If it's necessary, we'll deal with that in due course. Those are the submissions on behalf of the applicant. We submit for relief in the form sought in the notice of motion, the setting aside of the decision in question, with costs, including the costs of 3 counsel. Those are our submissions.
On the other ground that you've raised of legality, do you have further submissions to make, especially considering what your colleagues have considered on?
On the legality
Yes.
challenge? No, we don't have further submissions to make on that score at this stage. We've confined ourselves to the rationality of the decision. We haven't made any submissions or taken the submissions in our heads of argument any further in relation to whether or not a decision of this kind to discontinue a prosecution is administrative action or not. For the purposes of our submissions, we have contended it's not necessary to resolve that question.
Okay. Thank you very much, Mr. Rosenberg. Or do you wish to say anything further?
I was looking around.
One other piece of paper, but I can deal with that in reply if needs be, as the court.
Thank you very much. Mr. Epstein?
I'll start with stating the following. Mr. Zuma was to be recharged. That is to say, whether this should occur before or after the ANC's national conference held in Polokwane during December 2007. This was plainly most irregular and worthy of strong criticism. And again, the irregularity of Mr. McCarthy's conduct is not to be minimized. Now, I've stated that, and although I agree with that, it's not a submission that I make. That comes directly out of the DA's own founding affidavit. Mr. Self says in his founding affidavit at page 38, and if I may repeat it, to the degree that Mr. McCarthy was a party to manipulating the timing of exactly when Mr. Zuma was to be recharged, that is to say, whether this should occur before or after the ANC's national conference held in Polokwane during December 2007, this was plainly most irregular and worthy of strong criticism. And at page 39 of the founding affidavit, Mr. Self says, who's the deponent of the founding affidavit, again, the irregularity of Mr. McCarthy's conduct is not to be minimized, which we submit is what the DA has sought to do today, to try and minimize the conduct in the face of the statement by Mr. Self in his own affidavit that it is worthy of strong criticism and should not be minimized. It was a most serious abuse, which I will deal with later when I deal in more in depth with the facts.
Just raise this. In the affidavit of Mr. Hofmeyer, he's making references to a number of people, including Mr. McCarthy. Now, the allegations that are raised against Mr. McCarthy, Mr. Nmuka, Mr. Casrels, President Beki, how do we deal with this? Have these people been served with a document to give their views on what is being alleged against them? Because I don't know, what is the veracity of these allegations if the other parties have not been given an opportunity to respond to them and tell us whether they agree or not? That's the difficulty I have. Because if we are to say the decision taken by Mr. Mche was based on what he heard in the tape, one would imagine that the people who are implicated should have been given an opportunity to explain their actions before such allegations could be raised under oath in the papers. So I don't know, you help me out on that one. I have a difficulty with it.
Well, Justice Motley, firstly, they are not parties to this case. Secondly, Mr. Nmuka was given an opportunity. He was, it's in the papers that the questions were put to him and he gave a response. Mr. McCarthy was invited to respond and he elected not to do so. He placed some prerequisites in place which he then wanted determined before he would respond. And can I, in the same vein, refer to the following. In the judgment of Nicholson J., after the charges were set aside in 2008, there was strong reference to President Mbeki, and President Mbeki felt that he had been maligned by Nicholson J. And the matter then went on appeal to the Supreme Court of Appeal, and in that application, President Mbeki sought to intervene, and Haram's deputy president at the time, he said that he had no right to intervene. He is in no different position from a witness in a case who has been defamed or maligned, and he's not a party and he has no right to intervene. So this isn't a case about McCarthy being a party or Nuka being a party. They are referred to. It was open to everybody if they could get a response from them, including the DA, to approach them, get affidavits from them. And the fact is that what is on the tapes are recordings rather, of conversations between, inter alia, Nuka and McCarthy. And earlier on, the question was put to Mr. Rosenberg as to whether that's not a question of interpretation for the court. Well, we're not dealing with a document, where we know the law is that documents are, when to be interpreted, while there are rules of which may be used in aid of interpretation, ultimate interpretation is a matter for the court. But here we're talking about actual conversations which have simply been reduced to writing and transcript. And they do not constitute the entire conversation from beginning to end. The relevant extracts were taken by Mshe and put into his reasons. So the question of interpretation is not simply something which the court can look at in isolation. And like with interpretation of contracts, interpretation must be done within context. And there is a very large context to what is being said. And in order to understand what is being said, one needs to know what the context was, what Mr. McCarthy's role was before the recordings were made, and what role he had played. It's very important to understand who is Mr. McCarthy and what was his agenda and what was his motive in all of this. He was obviously he was head of the Directorate of Special Operations, and it was a very, very high position that he had, and he managed the prosecution. We don't say that he took the decision. It was a collaborative decision. It was what has been referred to as a corporate decision, but he played the major role. He was central to this entire process. So, Justice Motley, our submission is that those parties do not have a right to be here. If they wanted to, they could have approached either of the parties and said they want to file affidavits. And insofar as there may be a dispute as to what the meaning is of the recordings and how they were interpreted, well, then the applicant could have asked for that to go to oral evidence. And then the procedures could have been used to possibly subpoena them if they didn't come voluntarily, and they could have been cross-examined. But they haven't chosen to do so. Mr. McCarthy, who's now head of integrity at the World Bank, I understand, is far away and not coming anywhere near this court. So our submission is that it's something which this court must, and with respect, should take into account.
Yes, I hear what you're saying, but then there's a reference in the first respondent's affidavit to some theories that seem not to find support of the record. That when Mr. Nuka spoke to Mr. McCarthy, who then spoke to Mr. Casrels, and presumably it went to Mr. Mbeki, there seems to be no proof that such meetings were held. And that's my concern, that we cannot, that kind of evidence, you don't find it on the tapes. It was a statement by the deponent giving his theory of what could have happened. And I raise it because, as you heard the applicants indicate that Mr. NPA, when he took a decision, he said that President Mbeki might be involved behind the curtains. Now, if you take that statement and link it to what Mr. Hofmeyer is saying, stating them as a matter of fact, that's where I have a concern. I want to know whether indeed there were such meetings which Mr. Hofmeyer knows of, where Mr. Mbeki was present, and if that is the case, why he was not given an opportunity to state them. That's all I want to know.
There are direct statements by Hofmeyer as to discussions that he had with Nuka, and about where Hofmeyer was accused of failing in his duty to protect President Mbeki. And there are a number of references. It's true that assumptions are made, But the applicant brought this application. They've chosen not to ask for it to be referred to oral evidence. They're bound by the Plascon Evans rule. And if the court can't make a determination on that, well, then that's the problem, because that's the route they chose to take. But one can't do further from the respondent's point of view when all you've got is the recordings and you don't have access to Mr. McCarthy, and you can't force Mr. McCarthy to explain what happened. The best one can do is refer to the background, which I'm going to deal with, and which I submit will show overwhelmingly that that President that Nnuka and McCarthy were doing this in order to try and ensure that President Mbeki was successful at Polokwane.
But we'll take it up on argument tomorrow. I just want to pursue this, because if reference is made of a meeting with Mr. Mbeki, it's different from saying that certain two parties were doing it to advantage him. Was he aware? Was he involved? That's the nub of the question. If he was, where's the evidence to that effect? If he wasn't, then an allegation cannot be made that he was, in fact, party to the proceedings when it cannot be supported by document.
No, yeah, I do. Justice Modler, can I deal with this this way? There's no suggestion, there's no evidence that President Mbeki himself was conspiratorial in this prosecution. The point is that McCarthy and Nnuka, with or without the assistance of President Mbeki, were proceeding with one agenda and one motive, and that was to try and ensure that President Mbeki was successful at Polokwane. So there's no evidence that President Mbeki was involved in this, but it's what McCarthy was doing. And I will endeavor to show you that the conclusion is inescapable, that McCarthy was doing this with one point in mind, and that he was manipulating the prosecutorial process for a political agenda that he had and that Nnuka had. Can I also, in the same vein as I started, refer to what a memorandum by Mr. Downer, who was the head of the prosecution team, which is at D209. If I can put this in context before I refer to the relevant portion. What had happened was on the 4th of December, Mr. Mshe had contacted Mr. Downer to say there's a possibility that the serving of the indictment might be delayed. And Mr. Downer was not happy with that, and 2 days later, on the 6th of December, Mshe phoned Downer and said, the decision has been made, it's going to be postponed. And Mr. Downer was very angry indeed, and he said, I'm going to do a memorandum. And this is the memorandum that he does, at page 209. You'll see the subject is delay of the announcement of the decision to charge Zuma and Tint. And if I may take you to paragraph 7 of Downer's memorandum, which is addressed to the acting NDPP, which was Mshe. He says from paragraph 7, in every single instance where the incumbent NDPP has acted contrary to our advice, the results have been damaging to the case and to the NPA. It seems, however, that the lesson has not yet been learnt, that it is inadvisable for the prosecution to dabble in matters of politics, even with the best possible intentions. We fear that this instance will be no different. He continues, even if it is accepted that considerations other than purely prosecutorial ones should be considered, which we dispute, the team is nevertheless of the view that to deliberately withhold from the public the fact that a decision has been taken to prosecute the suspects until after the election of the ANC leadership for reasons which are unconnected with the prosecutorial process is in conflict with the constitutional duties of the team and the NPA. Now, of course, this was Freudian, and this is the leader of the prosecution team who was very keen to proceed with the prosecution. In 9, he says, we have the greatest sympathy for the acting NDPP's reluctance to be seen to interfere with the due political process that is about to unfold. We also appreciate the concerns relating to public order and stability. These may be particularly fragile now. It is our view, however, that if the decision to prosecute were to be announced in the normal course, as it would be in any other prosecution, the acting NDPP has nothing to fear. The moment the normal processes are deviated from, however, the NPA exposes itself to criticism from one court to another, which will be difficult to rebut. In the present case, there will never be a time when the same concerns will be any less pressing. The prosecution of very serious charges cannot be allowed to be subservient to these concerns. In the end, the prosecutorial imperative enshrined in Section 179 of our Constitution should prevail. This is that the NPA must exercise its functions without fear, favour or prejudice. This is echoed in our oath in terms of Section 32 of the NPA Act, our mission statement and the United Nations guidelines on the role of prosecutors. So clearly he foresaw the difficulties which would arise, and they've come to eventuate, about interfering in the prosecutorial process when one has another purpose, an extraneous purpose, and that is when one dabbles in politics, as it is put. I should add, if I could read just 12, the team feels so strongly about these principles that we have given serious consideration to terminating our involvement in this investigation. Ultimately, however, considerations of loyalty to the NPA and the country have persuaded us otherwise. Now, he saw this interference in his prosecution, which he was ready to proceed with. He saw it in the serious light in which it took place. And he did not know at that stage that McCarthy and Ngcuka had another agenda. He just thought this is being postponed because Polokwane is coming up and don't upset Polokwane and let's wait. He didn't know what the machinations were taking place behind the scenes, which I'm going to come to. Just in context and with respect, I know that you have this, but can I just say that we're talking about a period from 2005 through to 2009. In 2005, that was when Mr. Zuma was charged by Mr. Pikoli. And in July 2006, a year later, Msimang struck the matter from the roll and the charges were withdrawn. Then we go into the year 2006. That was when the Browse Mole report was produced by none other than McCarthy, who was head of the directorate, and he was behind the Browse Mole report, and I will indicate later the relevance and the impact that that report had on McCarthy's thinking and why he was pushing for the postponement of the delay in the institution of the prosecution. In 2007, that was when the Browse Mole report was leaked to the South African public. Interestingly, it was only in September 2007 that Mshe was appointed, and all these events took place in December. So he didn't have this background. He was appointed September 2007. In November, December, that's when McCarthy and Ngcuka were plotting and the phone calls were being recorded. On the 29th of November, the decision was taken to prosecute. And Dana was happy. Everybody was on board. It was all going ahead. And then the Polokwane conference, happened, and Mr. Zuma was elected then as the ANC president, and he was charged on the 28th of December 2007. In 2008, there was the Nicholson judgment. In September 2008, President Mbeki was recalled and President Motlanthe was appointed. And then in 2009, the SCA reversed the Nicholson judgment, and there was an application for leave to appeal to the Constitutional Court, and the representations were made, and by April, as we know, the charges were withdrawn. I just wanted to give you that context. We've made some additional notes which we'd like to hand up relating to submissions made in our heads of argument. It addresses 3 issues. It addresses the issue of review, as well as the NDPP's power of review, and it also addresses, insofar as it may be suggested that there are ex post facto reasons, we address those as well. I'd like to start firstly with the approach to review. Mr. Rosenberg said at the conclusion that they're not abandoning the submission that PAJA is applicable, but they rely on rationality and it really doesn't matter. Well, to this point, they still persist that it's a PAJA review, and we say it's not a PAJA review. It's a rationality test based on the principle of legality. And we refer to the case in paragraph 2 of freedom under law and the Director of Public Prosecutions. And that was that arose out of the Murphy J decision concerning Mdluli. It went to the SCA, and Brunt JA said that the PAJA precludes a review of a decision to prosecute, and a decision not to prosecute is the other side of the coin, and therefore PAJA is not applicable. The only basis to review is on the principle of legality. I've seen that they tried to distinguish it. We submit there's nothing to distinguish that case. It's of the same, the decision not to prosecute is of the same genus as a decision to prosecute. And we quote from the decision of Brunt J at the bottom of paragraph page 2, although decisions not to prosecute are in the same way as decisions to prosecute subject to judicial review, it does not extend to review on the wider basis of PAJA, but is limited to grounds of legality and rationality. The legality principle has by now become well established in our law as an alternative pathway to judicial review where PAJA finds no application. Thus, there's no merit in the DA's submission. We say that the present case is distinguishable from the full case. And if so far as they persist with that, we say it has no merit. We say, therefore, they can only challenge on the basis of the principle of rationality. And in paragraph 7, we say decisions of the acting national director are not immune from review by the courts. We know that. Right? But it is only in highly exceptional cases that the court will interfere with such decisions. Now, excuse me. A number of these cases are in our heads of argument, but if you'll just indulge me while I emphasize portions from the judgments. In Butto Star, which is the judgment of Justice O'Regan in the Constitutional Court, she said a court should be careful not to attribute to itself superior wisdom in relation to matters entrusted to other branches of government. A court should thus give due weight to findings of fact and policy decisions made by those with special expertise and experience in the field. We refer to MEC for Environmental Affairs versus Clarison. A review is not concerned with the correctness of a decision made by a functionary, but with whether he performed the function with which he was entrusted. When the law entrusts a functionary with a discretion, it means just that. The law gives recognition to the evaluation made by the functionary to whom the discretion is entrusted, and it is not open to a court to second-guess his evaluation. The role of a court is no more than to ensure that the decision-maker has performed the function with which he was entrusted. Clearly, the court below was of the view that the factors that we have referred to ought to have counted in favour of the application, whereas the MEC weighed them against it. But that is to question the correctness of the MEC's decision and not whether he performed the function with which he was entrusted. It may well be that when one looks at the rationality test, it may well be that when you look at what Mshe heard, what he considered, when he heard the tapes, when he considered the representations, it may well be that my lords and my lady may have come to a different conclusion. You might find that it wasn't reasonable. But being unreasonable doesn't mean you're irrational. You're allowed to be unreasonable, and you're allowed to be wrong. The court can't interfere simply because the court would have done something else. And it continues, in Canaland we refer to versus the Minister of Local Government, where Traverso DJP said, when a court is requested to review an administrative decision, the fundamental constitutional principle of the separation of powers is implicated. The separation of powers requires that where the Constitution or legislation has entrusted specific powers and functions to a branch of government, courts may not usurp those powers or functions by reconsidering the issues and making decisions according to their own preferences. This would frustrate the balance of power inherent in the principle of the separation of powers. The primary responsibility of the court entrusted with review jurisdiction is not to make decisions falling within the domain of other branches of government, but to ensure that the relevant branches of government exercise their authority within the limits of the Constitution. And the dictum of Nugent J.A. and Scalabrini is really, with respect, makes the point, where he described what rationality entails as follows. But an inquiry into rationality can be a slippery path that might easily take one inadvertently into assessing whether the decision was one that the court considers to be reasonable. Rationality entails that the decision is founded upon reason, in contradistinction to one made that is arbitrary, which is different to whether it was reasonably made. All that is required is a rational connection between the power being exercised and the decision, and a finding of objective irrationality will be rare. Whether the decision is rationally related to its purpose is a factual inquiry blended with a measure of judgment. It is here that the courts are enjoined not to stray into executive territory. So we just re-emphasize that whilst, if it should transpire, that the court feels that another decision would have been made by this court, it amounts to an interference in the discretion of the office bearer who was entitled to make this decision, and unless it was arbitrary, even if the court finds it unreasonable, the court can't interfere. Can I move forward in these submissions, with these notes we've handed up, and ask you to turn to page 13. Again, we refer to this in order to illustrate the discretion given to a director of prosecutions and to the trust reposed in a national director. The issue with Saint 24 in these proceedings is not whether the acting NDP's decision was right or wrong. Rather, it is whether it was a decision which he was lawfully entitled to make. And we refer to the decision of the House of Lords in Regina Corner House versus the Director of the Serious Fraud Office. I'll bring a copy of the judgment tomorrow. I really didn't think we'd get as far as we have today, and so I only have one copy here, but I'll bring a copy for tomorrow. Now, in that case, the House of Lords referred to the principle on which prosecutorial decisions are exercised by reference to the classic statement of the Attorney General Sir Hartley Shawcross in the House of Commons. He observed, "It has never been the rule in this country, I hope it never will be, that suspected criminal offences must automatically be the subject of prosecution." If I may pause there just to refer, perhaps I could ask you to make a note. It's in the founding papers at page 138 is the prosecution policy that we have. It's in B1. 1B. And I'm reading from the policy, that's our policy. It's at page 138. Perhaps I could ask you to look at bottom of page 137. bottom of page 137, and this section is on criteria governing the decision to prosecute. The bottom 137, against the letter C, prosecution in the public interest. Once a prosecutor is satisfied that there is sufficient evidence to provide a reasonable prospect of a conviction, a prosecution should normally follow, unless public interest demands otherwise. And 138, there is no rule in law which states that all the provable cases brought to the attention of the prosecuting authority must be prosecuted. On the contrary, any such rule would be too harsh and impose an impossible burden on the prosecutor and on a society interested in the fair administration of justice. And in the middle of the page, there's the heading, the interests of the victim and the broader community. The attitude of the victim of the offence towards the prosecution and the potential effects of discontinuing it. Care should be taken when considering this factor, since public interest may demand that certain crimes should be prosecuted, regardless of a complainant's wish not to proceed. The need for individual and general deterrence and the necessity of maintaining public confidence in the criminal justice system. And the prosecution priorities as determined from time to time the likely length and expense of the trial and whether or not a prosecution would be deemed counterproductive. I emphasize the second bullet point, which is the need for individual and general deterrence and the necessity of maintaining public confidence in the criminal justice system. If I could return then to our note at paragraph 25. So we refer to Regina versus the Director of the Serious Fraud Office. Sir Hartley Shawcross said, "It has never been the rule in this country, and I hope it never will be, that suspected criminal offences must automatically be the subject of prosecution." He went on, My honourable and learned friend then asked me how I direct myself in deciding whether or not to prosecute in a particular case. That is a very wide subject indeed. But there's only one consideration which is altogether excluded, and that is a repression of a given decision upon my personal or my party's or the government's political fortunes. That is a consideration which never enters into account. Apart from that, the Attorney General may have to have regard to a variety of considerations, all of them leading to a final question. Would a prosecution be in the public interest, including in that phrase, of course, the interests of justice? Prosecution may involve a question of public policy or national or sometimes international concern, but in cases like that, the Attorney General has to make up his mind, not as a party politician. He must, in a quasi-judicial way, consider the effect of prosecution upon the administration of law and of government in the abstract rather than in any party sense.
Mr. Epstein, I believe what stands here.
But here the decision has already been taken to prosecute in the present instance.
Yes.
The matter before the court, the decision was taken, there would be a prosecution, isn't that so?
Yes.
So this isn't relevant in that instance. That here it seems to me it's before they take a decision to prosecute, but in the present instance that decision had been taken already.
Yes. The principle will remain the same if I can just demonstrate what the facts were in the Corner House case.
Thank you.
The facts in this case were that there was an investigation. The United Kingdom had their own arms deal problems, and there was an investigation which was being conducted into a United Kingdom company. And one of the aspects concerned a valuable arms contract between the government of England and Saudi Arabia. And the Serious Fraud Squad intended to investigate bank accounts in Switzerland and whether payments had been made to an agent of an official of Saudi Arabia. And that provoked an explicit threat from the Saudi authorities. And what the Saudi authorities said is that if this investigation continues, they would no longer cooperate with security issues, and this was not long after 9/11, and they would stop negotiations to purchase Typhoon aircraft, and they would stop cooperating with the UK in the Middle East. And when that happened, the Director of Prosecutions decided not to proceed. He succumbed to the threat and he decided not to proceed. And the applicant brought an application before the High Court for an order directing that he must proceed with the prosecution and the High Court directed him to proceed. And the matter then went to the House of Lords, and the House of Lords held that the question which it had to determine was whether, in deciding that the public interest in pursuing any important investigation into alleged bribery was outweighed by the public interest in protecting the lives of British citizens, he had made a decision outside the lawful bounds of the discretion entrusted to him by Parliament. That is the question they had to answer. The court held that only in exceptional cases would the court disturb the decision of an independent prosecutor and investigator. That the evidence showed that the director's decision to discontinue the investigation had been taken with extreme reluctance, and although he had consulted with others, he had not surrendered his discretionary powers of decision to any third party, and that this decision had been one which he was lawfully entitled to make. And he submitted there is no basis in law for any suggested distinction between public interest factors which arise from a threat or those which arise from another circumstance which is factually relevant. Now,
think that it would be more ideal when dealing with the permanently stay the prosecution.
I'm sorry, but what do you mean in this application or in another application?
What we are raising up, of course, in the case that you have referred us to, the case was heard by the court. And in CASU, we are dealing with the review, to review the decision, whether was it rational or not.
So it's a reconsideration by the Acting National Director of Public Prosecutions of the decision to prosecute. It's a reconsideration. Further facts come to light, and the Acting NDPP takes a decision within his discretion to stop the prosecution. And what I'm illustrating is that on these principles, it's his discretion, and the courts will only intervene under the extreme circumstances.
Came into light in this case before.
In the present matter?
Yes.
Well, I'm going to turn to that, because I can't give it to the Lord in one sentence or one answer. But can I at least preview it this way? On the assumption that your Lordship and Lady finds that there was political interference, that the prosecution process was manipulated by a senior prosecutor together with a former national director for extraneous purposes and unconnected to the prosecution, but for their own political agenda, and in order to enhance and advance the position of President Mbeki. On the assumption that you come to that conclusion, the question is this: was the prosecution process tainted to such a degree that the administration of justice would fail if they proceeded with the prosecution, that the integrity of the NPA would be affected to such a degree that the public would lose confidence in the NPA? Now, it must not be minimized, to use the DA's own words. Mr. Rosenberg said that everybody's equal, so we're not talking about presidents, we're not talking about the ordinary man in the street. We're talking about everybody. Nobody must be treated differently. If the country we know is rife with violent crime, commercial crime, everybody must assume and know that if they are going to be charged by the prosecution authorities, that they are being charged by an authority conducting itself in terms of the Constitution, independently, without influence from anyone else. They must know that there's nobody in the background paying somebody for that prosecution. They must know that there isn't somebody who's got an agenda to prosecute them, that the force being brought about to bear in terms of that process is such that it's independent, and there's no other motivation other than to ensure that somebody who may have perpetrated a crime is charged, and if found guilty, then convicted.
opponent, Mr. Hofmeyer, about what is happening in the NPA. Don't you think that the public would lose trust in the NPA would lose trust in the system if this matter does not go to court?
I think, with all respect, Lord, it's actually the opposite. Because the public are influenced by what they read in the media. There's no doubt about the sentiment which exists in this matter and has for many years. The merits of this matter don't come into play. Judge, I think Justice Motley asked Mr. Rosenberg earlier. The merits don't come into play. Ordinarily, based on the merits, there would be a prosecution. So we don't deal with the merits. The question is whether you have a prosecution which is so affected by outside manipulations that the public lose confidence. We must think of a person who is going to be, or may presently or may in the future be, the subject of a criminal prosecution. That person is the one who has to also retain faith in the system. And that person must know that he or she is being prosecuted totally independently without anybody interfering. Now what happened here is, Mshe says, when he saw what was going on, he felt, and we'll look at his reasons, he felt that the administration of justice was so badly affected, that the integrity was so badly affected, that this prosecution could not continue. Now that's a view he formed. Unless you come to the conclusion that that is arbitrary. You may not agree with it, but that's a view that he formed. And he applied his mind. He listened to the recordings. Hofmeyer and Mzinyati, two senior people. Hofmeyer was the deputy national director. Mzinyati is the director. Both presidential appointments. They agreed with him that it was so serious that it had tainted the whole prosecution. And if this was another case, other than the one with which this country is so familiar over the last many years, perhaps a different view would be taken. But the public, we must do what is in the public interest, not is of what is interesting to the public. We must do what is in the public interest. And that is why I say take precedence out of it. You've got a situation where there was a prosecution where there was manipulation behind the scenes by the senior prosecutor to achieve his own ends.
But that was only in regards to the timing of when the indictment will be served. Was there any taint to the charges by Downer and Steinberg? And did they know anything about all this? Was it ever discussed with them again before the decision was taken? I didn't know about this decision until the last moment. Why was it not discussed with them once more?
Well, Downer, nobody knew about it until the recordings appeared in. I don't know exactly when they appeared, but McCarthy certainly, when he was arranging for this matter to be postponed, because Nuka is saying to him, don't charge him. Whatever you do, don't charge him before Friday. Because timing is everything. It wasn't just the timing. Would it make a difference to the merits, whether he was charged in December or January? The answer is no. But by charging him later than they intended, that would have a difference to the outcome that the prosecutor intended to achieve at Polokwane. Because he was of the view that if Mr. Zuma was charged in December, I see Mr. Omar says President Zuma behind me.
I'm sorry, my lord. Please defer to our learned president. We call him President Zuma. As my learned colleague each time refer to President Mbeki, it's President Zuma. He's the current president. He's serving our people for the second term of office. I'm humbly asking everyone here, please refer to my president as President Zuma. Siyabonga. Thank you, my lord.
Lords, unless you direct me otherwise, it takes it out of context. He wasn't the president at that time.
No, but I've recommended to everybody that I think maybe for the sake of respect for the office, let's refer to him as President.
You may want to say the third respondent. I see Mr. Rosenberg ended up doing that because then at that time when these things unfolded, he wasn't the president of the country.
Yes.
So you'll be safe to say the third respondent.
I'm going to be talking about the prosecution of President Zuma in 2007. He wasn't the president, right? Yes. But I'll try the third respondent.
Yes. But you know, we just want the public to have confidence and to see that the courts are respectful to the litigants who are before it.
I just don't want it to be thought, if I say that he was charging President Zuma in December 2007 when he wasn't the president. But I'll take it.
Let's proceed and not waste more time on this issue.
No, I was dealing with timing.
Yeah, you're still answering the question raised by my sister there. You see, you use the phrase, the prosecution process was contaminated. And when we read the reasons by Mr. NPA, he confines the contamination to the timing of the service of an indictment. Now, to what extent that can taint the entire process of prosecution is what I'm interested in knowing from you. Because if the reason was that the objectives that the other two gentlemen are alleged to have had was to influence the outcome of the election through the timing of the service of the indictment, the real question is, how does that then affect the entire prosecution?
So our submission is that timing is everything, because the whole idea behind delaying it, where Mr. Downer said, we are ready, we must proceed, this is going to come back and bite us. Don't delay it for political reasons. We must proceed. And it was being delayed for one reason only, and that was for a political purpose. And that is why the timing matters. It doesn't matter to the merits of the case. Let me try and explain it this way by giving an unconnected, unrelated, exaggerated example. Assuming there's a prosecution in the magistrate's court in a particular jurisdiction, and there's a good, solid case which the prosecutor believes he has against an accused. But somebody who's the complainant wants to ensure that it happens more quickly, and he goes and he bribes the prosecutor. To say, well, it doesn't affect the merits, ignores the fact that the process has been abused. That is the problem. The NPA must remain squeaky clean. We know it's been dysfunctional over the years. We know there are problems within the NPA. We know about all the infighting. Nobody can get away from that. But to say that because the NPA is not squeaky clean, it doesn't have to now try and restore its own integrity, ignores the problem. The problem is that the person who was running with this prosecution had his own agenda. It was a political agenda. That's why timing matters. It doesn't matter to the merits. Whether he'd been charged in December or January wouldn't have made an outcome, had an outcome in terms of the merits. And then when Mshe sees what his senior prosecutor has been doing and how he's been delaying it and the reasons why he was delaying it, he says this process has been tainted. And I come back to this, then I can only, not to sound like an old broken record player for those who remember those things, it's not whether you think that that's a decision you would have taken. You may not have. The question is it irrational? It may be unreasonable. But he says, when he starts his reasons, he says, this is one of, if not one, I think this is the most difficult decision I've had to make in my life. Because he's thought about it. And he knows he doesn't want the prosecution not to proceed. He would prefer the prosecution to proceed. He says, I stand before you today to announce the most difficult decision I've ever made in my life. It was not an easy task at all. I had the privilege of having listened to inputs and comments of very eminent jurists of the NPA, and I'm thankful to them for their candid and frank arguments. When I was interrupted earlier, I was saying that the persons who agreed with Mshe were Hofmeyr, and Mzinyati. Hofmeyr was a deputy national director, and Mzinyati was a director. They appoint presidential appointments. They hold high positions. They took a view. They were aghast at what had happened as well. And they discussed that. And Hofmeyr confirms on an affidavit where he says, we all agreed. I think earlier on, Justice Motley, you asked whether, but they had agreed.
You have printed out the picture of the two gentlemen, Messrs. McCarthy and Mr. Nuka, having an agenda of their own, seeking to postpone for the reason of that agenda, to manipulate the outcome of whatever was taking place in Polokwane. That I understand. But now the facts here point out, and I'd like you to address me on that the decision that the indictment must be served after Polokwane was taken by Mr. Mche himself. And he said, this is my decision and mine alone. And if he took that decision, the reasons that were raised were that he was concerned about what may become a public fallout with that. I don't know if you follow what I'm saying.
I follow what you're saying.
Yes, his reasons have nothing to do with the manipulation of the outcome, but his reasons that took into account what was happening at that time. And that's what we get from Hofmeyr's affidavit. That, well, he says, Hofmeyr continues to say that he was influenced by McCarthy to do so, but that's something else that we'll go into. But at this point in time, the decision not to serve the indictment before the Polokwane conference, was it taken by McCarthy or was it taken by Mche? If it was taken by Mche, then you will have to address us on that as to what was his agenda.
My answer is going to be, when I go through the facts, that it was a decision of McCarthy to which Mche deferred. He didn't like it, but he deferred to it, and he says so in his affidavit, and he then conveyed that to Downer. But it really was a manipulation by McCarthy to get Mche to agree to the postponement. And that becomes clear when you have the affidavit of Hofmeyr saying that he had been approached by Mche about postponing the matter, and that Mche then confirmed to Hofmeyr that he too had been lobbied by by McCarthy to postpone the matter. And finally he said to McCarthy, I'm not in agreement with you, but I will go along with it. And then what happens is McCarthy phones Downer, and McCarthy represents to Downer, he lies to him, and he represents him that he is aggrieved by this decision about the postponement, and he didn't want it postponed, when it's quite clear that he was the driving force behind the postponement all along. So it really was Mche who'd come on board in September. McCarthy was running with this prosecution. He was managing it, and Mche says on affidavit, I didn't want the matter postponed, but if it was McCarthy's decision, I went along with it, and he explains that he then conveyed it to Downer.
Where do you find this? Mche says that.
Can I ask you to look at Mche's affidavit, which is in volume 34, I think it is, the volume 34, at page 3186, I think it says. And just pull out Hofmeyr for me at once, at page, at Hofmeyr, page 172. So at page 3188, this is the Mshe's supplementary affidavit to which there's been no response, no reply. It was not contradicted. He's at 3187, there's a heading, McCarthy's attempts to persuade me that the prosecution should be delayed. 5, I do not remember the exact date at which McCarthy spoke to me about delaying the announcement of the NPA's decision. I do recall, however, it was shortly after the deputies' meeting took place on 29 November. Although McCarthy was on leave for much of the period, he did come to Pretoria various meetings. He was in Pretoria during the period 30 November to 6 December. They looked at the cell phone recordings, he goes on to say, and they determined from the cell phone recordings because they can indicate where the person is when the cell phone call is made, and he was in Pretoria. And that's why he says at the top of 3188, it includes all, he refers to Steyn, who established McCarthy was where he was. The applicant contends that McCarthy was in Cape Town during the period. For this reason, it maintains that McCarthy could not have spoken to me about postponing the Zuma prosecution. Steyn's examination proved otherwise. Paragraph 10. McCarthy had a habit of just coming into my office if he wanted to discuss something with me. He did not wait to make a formal meeting. He came to my office and told me that he wanted to talk to me about postponing the Zuma prosecution. I did not initially support McCarthy's view that it was necessary to postpone the Zuma prosecution. I was aware of the prosecution team's views. I knew that they were anxious for the prosecution to commence as soon as possible. In the criminal trial, both President Zuma and the presiding judge had criticized the NPA for delays in finalizing the investigation. We anticipated that once President Zuma was charged, he would launch a stay application. The delays in finalizing the prosecution were bound to be an issue as they had been in the past. We knew that any further delays in finalizing the prosecution would count against us in the stay application. I knew that the prosecution team felt strongly that any delay in announcing or commencing the prosecution was likely to have serious consequences in future proceedings and would be portrayed as an attempt by the NPA to manipulate the case. And then 12, the decision to prosecute had already been made. It was made on 29 November. On that day, the prosecution team made a presentation to the deputies meeting, which they recommended that the charges against President Zuma include a charge of racketeering. The recommendation was accepted. I asked the prosecution team to prepare the Section 33 report to the Minister on my behalf. They sent me the report on Monday, 3rd December. It was recorded that the decision to prosecute President Zuma had been taken and that the prosecution would be instituted as soon as possible, because there was no legitimate reason to delay it. That is, no reason related to the prosecution itself. Initially, I did not agree with McCarthy that the prosecution should be postponed. His suggestion came out of the blue, as it had never been mentioned to me. At the time, I was not aware that McCarthy had spoken to Down and Hofmeyer about delaying the prosecution. Nevertheless, I accepted that McCarthy had the authority to make the decision. He felt strongly about the issue. I do not see the point of engaging in any serious debate with him. McCarthy was in charge of the investigation and prosecution. I do not have the authority to instruct him otherwise. That meant that he could decide when to institute the prosecution. I made it clear on more than one occasion that all decisions related to the Zuma prosecution would be left to McCarthy and his team, and that I and the other deputies would only give input and indicate our views. This was because McCarthy was under no legal obligation to consult me or to take account of my views. McCarthy told me that it would be harmful to the NPA, particularly the DSO, which was under severe attack at the time, if Mr. Zuma was prosecuted before the Polokwane Conference. He believed that if he were to be charged before the Polokwane Conference, it would destabilize the DSO and the NPA and the country. He was wrong when he thought that he didn't have the power to overrule McCarthy. He did. But that was the view he took at the time, and he guided himself based on that.
So if we accept what is stated on the affidavit, it means then what is stated in the notes of Mr. Downer, that he told him that the decision to prosecute should be stayed until after Polokwane is his and no one else's. Yes. What are we to do with that statement?
I think he explains it. If I can just find that. 25. At paragraph 25, 5. I met with the 24. I met with the minister during the evening of 5 December. I raised with her the issue that the announcement would possibly be delayed. It was clear to me that she agreed that the prosecution should be delayed. She was concerned that the NPA would be perceived as targeting Mr. Zuma ahead of the Polokwane conference. The following day, 6 December, I telephoned Dana to inform him of the decision to delay the prosecution. I told Dana that I had taken the decision to postpone the prosecution independently. I told him that it was my decision and my decision alone. I did so because Dana was aware that I had met the minister the previous day. I did not want him to think that the minister had interfered or that the minister had unduly influenced me. I did not tell Dana that it was McCarthy who had persuaded me that it was necessary and that delaying the prosecution was the better option for the NPA. I knew that the decision to delay the prosecution was likely to be unpopular. I knew that Dana would be unhappy with that decision. And he also says, as the head of the NPA, I felt that I had to support the decision. McCarthy had already made the decision. I did not want to blame it on others when I knew it was likely to be unpopular. As expected, Dana was angry about the decision to postpone the prosecution. Yes, I should complete the picture. Paragraph 28, Mshe says, soon after my conversation with Dana, I went on leave. My last day was on 14 December. I was due back at work early the following year. When I went on leave, I was under the impression that Mr. Zuma would be prosecuted in the new year. It's just in Hoffman's affidavit, he just confirms that everybody wanted the prosecution to proceed. Everybody thought it was going to proceed, but McCarthy was lobbying behind the scenes. And once the prosecution was delayed, and as soon as Polokwane was over, and Mshe says that paragraph 29, on 19 December 2007, following President Mbek's defeat to Mr. Zuma, McCarthy decided to institute the prosecution. We know this because on 19 December, he told Mnuka that he hoped to be able to, quote, move by Friday, i.e. by 21 December.
He did not decide to institute the prosecution.
He decided to serve the indictment. The prosecution's decision had been taken long ago.
Yes.
It had come and gone already.
I with respect, I accept that. We're talking about the indictment.
Yes.
Yeah. And Mshe says he did not consult me, he made the decision independently. He knew he had the power to do so, and he did. So straight after Polokwane, when he says we've got egg over our faces, we're bleeding, and then he immediately takes the decision to serve the indictment. And Mshe doesn't know this, because Mshe gives an interview to Radio 702, and he's asked, when are you going to institute the charges? And he says in the new year. And then he gets a telephone call from McCarthy to say, what are you talking about? I'm going to charge him right now. And Mshe was annoyed. He said, I've now made a fool of myself to the public. I've told them it's next year. In the meanwhile, it's going to happen immediately. And it does happen immediately. Point of this is McCarthy is central to all of this. McCarthy is the person who's managing this entire prosecution. Now, when the representations were made in 2009 to the NPA. First, oral representations were made, and various matters. First, written representations, and then oral representations were made. But the recordings were not produced immediately. The NPA were told that there are recordings, but they were not yet produced at that time.
And before the recordings were produced, and the Browse-Moore report.
I'm sorry, what, at which stage?
I'm saying before the tapes were produced, Mr. Mche knew that McCarthy was also involved in respect of the Browse-Moore report. And then at that stage, before the production of the cassettes, that did not persuade him to discontinue with the charges.
No, at that stage not.
Yes.
At that stage not. The Browse-Moore issue was raised when the representations were made. When the oral representations were made, Hofmeyr says that amongst the issues which were raised was the Browse-Moore report.
Before the draft letter was written, the Browse-Moore report was considered with all the other representations at the time.
Except the recordings had not yet been listened to.
Because they were not available yet.
Because Hofmeyr says at page Zuma representation starts at 235. President Zuma. It says at 237. Paragraph 243, Hulley disclosed that he was in possession of recordings of conversations between McCarthy and various politicians, including Nilka, Zeev Kumalo, and Ronnie Kasrils. He maintained that the recordings proved that McCarthy manipulated the timing of the decision to charge the third respondent and that he had deliberately delayed the decision until after Polokwane, with one purpose in mind, to undermine the third respondent's chances of being elected as ANC president at Polokwane. Following the third respondent's election and President Becky's defeat, McCarthy had moved with haste to charge him. And then at 246, Hulley and Kemp related further of examples that they had linked individuals in the NPA past and present to a conspiracy to discredit the third respondent. And they included Nuka's announcement in 2003 that he had decided not to charge the third respondent along with Sheikh, and in 246.2 the fact that McCarthy used the resources of the NPA, the DSO, to source negative intelligence about the third respondent. That points specifically to McCarthy's role in the Browse-Moore project, which was an intelligence gathering project.
That we wanted to put forward was that before Mr. Mche took the decision on the first, he was aware that McCarthy was also involved in the Browse-Moore report. And when they discussed with the team, the decision then was that the prosecution would continue.
From the draft letter?
Yes.
Yes, the draft letter implied that they were going to reject, it implied, this is draft letter, that they were going to reject the representations. I think even Hofmeyr says they were not signed, they were not under oath. But importantly in that draft letter, if I can just go to it, it's D7. If I could just have a moment to find my D7. appropriate place where he says. Give me a second. Right in front of me. Thanks. At paragraph 5 of D13, there is reference to alleged political conspiracy and abuses of process. This aspect of your representations has occasioned great anguish. About 4 lines down, I'm firmly of the view, therefore, that these allegations are not matters to be suppressed and concealed, but rather ones which must be vigorously and transparently investigated and determined. Although I'm advised that the material to which you granted Mr. Hoffman and Advocate Mzinyati access seemed to them to be authentic and reliable, that has not been established conclusively and can only be done if and when the original material is made available for detailed examination. Moreover, the manner in which the material was obtained and or passed on to your client and to you to be used for his benefit and the legality of actions of all those involved are unknown. These matters too must be the subject of further investigation. So at this stage, they were still coming back with further representations, and he had, and certainly Mshe had not yet listened to the transcripts. This is, I think, early March. He only listened to them on the 31st of March. Which is, there's no date, but he only listened to them on the 31st of March. I hadn't applied my mind to this letter before it was raised this morning, so I'd like another opportunity to look at it, but I think this letter was drafted by Mr. Downer and not by Mshe.
It's a recommendation to Mshe.
Yes, this was the... Mr. Manechi points out, this was the recommendation to Mshe by Downer.
Downer as an individual alone.
No, he was the head of the prosecution.
But this letter was also taken to Advocate Trengov by Hofmeyer and another person. So it's not only Downer who was involved in it. It was taken to Advocate Trengov for him to make corrections.
But ultimately it's got to be Mshe's decision. Other people are drafting it, and he hasn't listened to the tapes yet. We submit that when one considers the role of McCarthy, one can't look at McCarthy's role without looking at his background and his involvement with the Browse-Moll report. We've said that the whole motivation behind McCarthy's actions, from his point of view, was to support President Mbeki and to ensure that he was successful at Polokwane. And one understands that. That's why I say that when one interprets the conversations, it's done in context. It's done with knowledge of the background of why he was doing this, why he was saying the things that he was saying. And that context comes from the Browse-Moll report. It might open old wounds, but we're looking at what happened at the time, and it's important. And that was the report, which the report is in the it's in the bundle at page 874. Not bundle, it's in volume 10 at page 874 was the report. And then there's the report of the Joint Standing Committee on Intelligence, which is at page 908. But it's important as to what they said about McCarthy in that. And you recall that the report contained allegations that the third respondent was involved in a conspiracy which was a threat to the sovereignty and integrity of the South African state, and said that the president of Angola...
But despite that, the prosecution decided that they were still going to proceed up to until after Mche listened to the tapes.
Yes.
So I want to understand from you, what is the relevance of you quoting to us what happened regarding that report?
The relevance is clearly that to show that McCarthy, from as far back as the Browse-Mole report, when it was recommended that steps be taken against him, when steps weren't taken against him, when Picoli told him to stop and he didn't stop, and there's a very serious criticism of his conduct, and this whole process in the Browse-Mole report, everything he was doing there was aimed at trying to prevent the third respondent from taking over from President Mbeki. So since 2006, McCarthy's role has been to try and create conspiracy.
For the court, before Judge Nicholson, this report formed part of the record before the SCA, and still thereafter, the team decided to proceed with the prosecution. Now, do you want that it should be given another weight in this decision?
With respect, well, that's not the point.
Well, what is the
The
point?
point is that one is looking at why McCarthy arranged for this, the service of the indictment to be delayed. Why did he do that? A decision had been taken on the 29th of November to prosecute the third respondent. That decision was taken, but he's not prosecuted until he gets served with an indictment. There may be many people who are out there who are about to be prosecuted and they don't know it, where a decision has been taken. The fact is that he is only prosecuted when he gets the indictment. And now you've got McCarthy, for his own political reasons, delaying the decision. He's a prosecutor. He's supposed to be above reproach. He's supposed to show complete and utter integrity. He is the beacon of the National Prosecuting Authority. He's prosecuting one of the most high-profile people in the country at the time. He has to show complete and utter integrity with him and with everybody else. And behind the scenes, what he is doing is he is manipulating when the charges are brought, and he's doing it to make sure that President Mbeki gets elected at Polokwane. That's what he does.
Proceed with your notes. I'll try not to interrupt you.
I just needed some clarity on this last point. The point that has been raised is that prior to the 1st of April, when the decision was taken, all this information that you are taking us through was known to Mr. Mche. It was known. And it's not that it's something he discovered after listening to the tapes, that there was a Browse-Mole report. He knew it before then. And he was part of the decision to say, we are proceeding with the prosecution, notwithstanding the information we have. Now, what we don't have before us is, after being briefed by Hofmeyr and Zinyati about the content of the tapes, when he himself listened to the tapes, we are not told what is it that is new which he found there that caused him to change his mind not to continue with the prosecution. We are not told that. He listened to the tape knowing what the contents were because he had been briefed. He listened to the tape knowing that Mr. McCarthy was involved in the Browse-Mole some months before. He did that. But right up to, according to Hofmeyr, right up to that moment when he had to listen to the tape on the evening of the 31st of March, he was of the view that the prosecution should proceed. What we miss here is what made him change his mind, which he did not know before. That is the question that my brother here is raising.
I've clearly not been successful yet in conveying to you the relevance of the tape recordings, which don't stand alone. that do not stand alone. When it was put to Mr. Rosenberg earlier today that interpretation is a matter for the court, it can only be considered and interpreted in the context. And what is the context? The context is what was known to Mshe when he listened to those tape recordings. Those tape recordings listened to by somebody else may have had a completely different meaning if they did not know the background to the Browse Mole report and what Mshe himself knew. Everything fell into place for him once he'd heard the tape recording. That is why he says that he was shocked. Hofmeyr says he was shocked. Mzeniati was shocked. They were all shocked as a result of the tape recordings, because I think Hofmeyr was familiar with the Browse Mole report. So it is the context. What do those tape recordings mean? They mean everything when Mshe listens to them and knows what he does know about the Browse Mole report.
But he doesn't tell us
Is that Mr. Epstein?
It's it.
In his
Where do we find that in the papers? Where does he tell us that with everything I knew about the Browse Mole report and the McCarthy trying to delay the service of the indictment and listening to the tapes, all that falls in place. I don't know where did we find that in the papers.
Well, Milady, if one is looking to say that when you read his media statement, it was not all his reasons. That's his media statement that he put out. If one is looking for everything in there, one may not find it. But if you read it with what is said in the affidavits, then it raises the question, is this ex post facto? No, it's not. Now, what I'd like to do is I would like to say that he is not bound, he's not tied to exactly what is stated in the media statement as the reasons. They can be expanded upon. And this isn't a Pudger review where one is entitled to ask for reasons and reasons must be furnished. This is a rationality review where reasons were given in the media statement and he's entitled to expand on them as long as they are not ex post facto, thought up afterwards reasons. And we submit that when you look at what is said in the affidavits, they are not thought up afterwards. And in fact, may I Yes, importantly on this very point, Mr. Manetti refers me to Hofmeyr's affidavit at page 247, paragraph 269. 269. Where he says, Mshe felt betrayed by McCarthy. This is after he's now listened to the recordings. Once he heard the recordings, he realized the extent to which McCarthy had manipulated him and others in the NPA. He understood then that McCarthy's insistence that the institution of the prosecution be delayed was not innocent. Rather, it was politically motivated. McCarthy had abused his trust. He had manipulated him to ensure that the prosecution was delayed. He had reluctantly agreed. And then when it no longer suited him and others close to President Mbeki, he had finalized the prosecution contrary to the wishes of Mshe. Mshe was also struck by the disrespectful jibes that McCarthy and others made about him and Hofmeyr when he spoke about them to others. So that is what fell into place for him. He states that now he realized what was going on. Where was I there with that? I wanted to refer in the document which I handed up to you. I wanted to refer to the new what we call the new reasons argument, which is at page 7. I must get a cup to my patron here. We say there's no impediment to providing additional reasons where they are not ex post facto reasons, and accordingly not the reasons it should be for. No, sorry, not two reasons for the decision. I'm reading paragraph 12. The DA submits that it is not open to the NPA, quote, to remedy Mshe's decisions by putting up additional new reasons in an attempt to redeem the decision. For this submission, the DA relies upon the authorities set out in paragraph 76 to 78 of their heads. The applicant invokes Jikama, which was cited in the National Lottery Board case, where Kachalia J. stated, the question here is not whether there were other reasons in the record that justified the board's decision, but whether it could give reasons other than those it gave initially for refusing the application. The decision in the lottery case was obiter. Then we say what the binding law is. The binding law is in paragraph 16. It's the case of Van Zyl versus the government of the Republic. Here the appellants argue that the government was disallowed from advancing a new reason, namely the influence of policy considerations in its answering affidavit, not to be found in correspondence between the parties prior to the launching of the application. On the facts, the appellants had requested the government to provide diplomatic protection against the government of Lesotho after the cancellation of mineral leases. Harms wrote, the government obtained legal advice from different persons. It held meetings with Mr. Van Zyl and his delegation of lawyers and international legal experts. Inter- and intra-departmental memoranda were prepared. The government considered the request carefully over a period of time, and it made a policy decision. First by the Deputy Minister, then by the Minister, and eventually by the President himself, who twice considered the matter. Then the applicant urged that overarching policy considerations not mentioned in the correspondence prior to launch of the application constituted new reasons. And rejecting that argument, Harams J.A. held the case should come on which the appellants rely for the principle that an organ of state is not entitled to raise new reasons for an administrative decision and an answering affidavit was one where the new reasons were ex post facto reasons and accordingly not the true reasons for the decision. So hence the point in paragraph 17 we say the point is not whether or not all the reasons appeared in the correspondence prior to the litigation, but whether these were in fact pretexts which in fact played no part in the decision-making process. And in footnote 22, if I can refer you to that, there's reference to the case of Hijazi versus Kensington Council. Nothing objectionable in a decision maker making a subsequent statement in which he identifies the material which he took into account in the course of the decision-making process. And then we refer to Bistorm, judgment of Skippers J. That distinguished case of Jikama. There's reference to the English authorities at paragraph 20. I don't want to delay the court on that. And paragraph 21, we make the point that this must be seen in the context of the fact that this is a judicial review in terms of the Constitution, and there's no statutory obligation to furnish reasons. The statement made by the NDPP of 6 April was a media statement. It was not the equivalent of a response to a request for reasons in terms of Paja. It must also be remembered that there were confidential elements that had been conveyed to the NDPP when the representations were made. And further in this regard, the court in review proceedings will approach the manner in which an administrative authority has chosen to give effect to its duty to furnish reasons with an institutional committee. The Minister of Education versus Bovellon, it was held that so long as the gist of the received reasons was conveyed, the provincial MEC was not obliged to spell out why particular schools were considered for closure. And finally, Young Men Shan versus Shagan, the mere fact that the tribunal did not mention in its ruling every fact or circumstance that it took into account does not warrant a review of that ruling. Sometimes even the briefest of reasons suffice. And Canada, and finally, Traverso GJP, having held that a court must defer to the MEC's decision on the merits, went on to reject the municipality's complaint about the explanation offered by the MEC. He had said little more than that the evidence did not justify guilty finding. Despite describing this as terse, the court did not disturb the decision. So the point is that it doesn't have to be that every single thing was stated in the media statement is the precise reason. And clearly, I mean, we know that even judges consider matters, do a judgment, and sometimes there's a purported application to appeal on the basis that a judge didn't mention a particular point. Well, the judge doesn't have to. Doesn't mean that this is not mentioned, that it wasn't taken into account. So we submit that the reasons given can be read together with the affidavit of Hofbray. I am going to.
It's almost 4 o'clock now. Have you made submissions that you wish to make on the point that we are on?
No, there'll be a new plan.
There'll be a new point. And I think it would be appropriate to adjourn to 10 o'clock. We'll commence tomorrow at 10 o'clock. Court adjourns.
All right.
But the boards, we're going to leave the boards here. Ja, I